I mentioned item number 12 here.
Yes.
I mentioned item number 12 here. There, though it's a matter of 2017, affidavit in opposition has been filed very recently by the respondents a lot. There are some factual issues have to be clarified in a reply a lot. We need 2 weeks time to file a reply.
We'll take it up. When we take up the matter, we'll consider. These are not matters to be mentioned. Yes, next.
It is a Lordship. Lordship, I'd like to mention for listing of a writ petition pertaining to pensionary benefits, Lordship.
So, why?
Lordship, it has not been listed for quite some time, and on the last occasions when it was listed, it never reached, and it has been more than 1.5 years that the person has not received his, her benefits. Any feasible date, Lordship?
Yeah, we'll have it on 14th of June.
Lordship, item number 2. My lord, matter may be permitted to be withdrawn, my lord.
Huh?
Item number 2.
You want to withdraw?
My lord, in practice.
Your name?
S.G. Borua.
Miss S.J. Borua, the learned counsel. You are there? Appearing on behalf of the petitioner. The learned counsel admits that the matter has become infructuous, and as such, admits that she has instructions to withdraw the matter. In that view of the matter, the petition stands closed.
That's a placement. Yeah, please, your lordship, I beg to mention item number 52. Kindly matter may be adjourned for 2 weeks, lordship. The
52,
lordship. The consent has been taken, lordship.
Miss
Ellen Sharma.
Ellen Sharma, appearing on behalf of the petitioner.
And respondent, lordship.
You are respondent? Which respondent?
Behalf of K. Gogoi, lord.
Huh?
Behalf of K. Gogoi, lord.
Item number 52, right? Some sort of petitioner. But date may kindly be fixed. Matter basically pertains to retirement benefit.
Pertains to?
Retirement benefit.
Why? What order was passed on the last occasion? We'll see when the matter is passed. Yes, Mr. Gogoi. Why are you asking an adjournment in this matter? 52.
Lordship, some difficulties. I have to hold the medical lordship, so emergency is there also. So
Okay. Understood. But why the matter has come today?
matter lordship regarding some, I have to obtain some instruction. So lordship, I have not getting the instruction yet also. So lordship may
Yes, instructions for what?
instructions regarding lordship that petitioner is entitled or not, lordship.
Entitled for what or not?
That pensionary benefit, other benefit, lordship.
Okay. Last order passed? Continue.
Lordship may after 2 weeks in the
No,
meantime.
I'll pick the date.
Lordship.
If it is a case of instructions. Oh, there it is there. Item number 52 for April.
Lordship. I have also taken consent from a senior brother, lordship.
But Mr. K. Gogoi, the learned standing counsel for the higher education department
Tesco University, lordship.
for Texas University, who submits that the instruction as sought for by the order dated 29/3/2023 have not been received, for which he seeks an accommodation. Taking into account the above, this court therefore fixes this matter again on 12th of June 2023, on which date the learned counsel for the respondent numbers 1, 2, and 3 shall obtain the instructions as sought for by order dated 29/3/2023 without fail.
May I please, Lordship?
Hmm.
I beg to mention for item number 48, in which we file and rejoinder affidavit dated 26/5/2020, which is not on record. Lordship, kindly be now to
You want to call it?
Lordship, hear the requisition of that.
Yes, Mr. Dol.
My lord, I'm praying for this item of 50 to be upgraded. That Amicus.
Oh, yes.
There are some developments, so my lord.
Item number 53
58, my lord.
or 58. Okay. Your name has not been shown, no?
No, my lord.
We'll take it up at 2.
My lord.
May I please your lordship?
Lordship, there is 3 methods pertaining to transfer can fix it.
It's an arting basis.
You want to do it today?
Yes.
Unlisted?
Yes, Lordship.
Okay.
At
Go.
2.
May I please, with the concern of the other side, I beg to mention item 17.
17?
17. Lord.
17?
My senior is out of station. Lord. I was led by senior counsel KP Patel.
Item number 17.
Yes.
Oh, that matter.
Yes.
Has the service been complete upon the about that Biswanath Sariali Municipal Board?
Lordship.
Service is complete. Then why you are asking for adjournment? Don't ask. You do it. Don't require seniors for that.
Public.
In item number 8, Lordship, we have challenged the virus of section 3(2) of the Provincialization Act 2017. Oh, probably also matter of
Item?
item number 8.
Hmm.
We have challenged the virus of section 3(2)
Yes.
of the Provincialization Act 2017.
Okay. So it should go before the division bench. Mr.
Askeda.
S.K. Das, the learned counsel appearing on behalf of the petitioner, submits that as the writ petition has been filed challenging the virus of section 3(2) of that long name Asar 2017 connector.
Assam Education, Packet Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017.
And as such, he submits that the matter should be placed before the division bench. In that view of the matter, the registry is directed to list the matter before the division bench.
As per Guwahati High Court rules. As per Guwahati High Court rules. Okay.
Item 1.
In this matter, some development is there, madam. In this matter, some development is there.
Yes, what is the development?
The development that they have dismantled the staircase. Now they are, a committee was constituted. They have prepared some drawings for revised drawing for making some construction. So I pray, madam, that it may 2 weeks time may be granted. We shall file the affidavit. We may withdraw also. We may have to withdraw.
Writ of mandamus be not issued directing the respondent to redesign and relocate the foot overbridge at such convenient place, thereby not blocking the flow of the petitioner's land of so and so as to enable the petitioner to effectively utilize the frontage of the imam. Where?
Well, in the dispute, my lord.
It has been done.
Yes, dismantle has been done now, my lord, and so this committee has prepared some drawing, my lord. We have not received it. We want to see that, my lord. It may be necessary. We must
Then
do.
if something happens, you file it separately. I give you the leave. If something happens, in the meantime, they have dismantled.
My lord, there was no direction from the Honorable Court. This is out of court, my lord. They have approached maybe, and my lord, physically I have seen, yes, because I cross that road every day, my lord. So I have seen that part has been, my lord, has taken out. And authority is doing something, my lord, a new construction. That is there, but I don't have any written instructions. But yes, this much I can confirm that footbridge is, as of today, that is not there. Government has taken their own call, my lord. There was no direction from the Honorable Court. Because we have filed our affidavit stating that, my lord, we cannot do it. Because, my lord, it was for public use, my lord. And suppose, my lord, today, this footbridge was, my lord, specially designed in such a way that, my lord, that even this disabled person, everybody they can use. There are escalators, then this, their lift and the footbridge. So, my lord, we contested this case stating that, my lord, that the court may not pass any mandamus because this is for public, my lord. This is for common good, for everybody, my lord. And their thing is that they all disputed question of facts that has landed before their thing. But we said that there is enough space to go inside. There is a 16 feet road. So, my lord,
You have constructed the footbridge in the land of theirs?
no. It is on
In
the road.
front of the- In the front of the lane, my lord.
In the front of the land?
We have,
Is your ingress and egress
Yes, my lord.
affected?
Totally, my lord, virtually a small portion limited.
You can't go inside?
My lord, we can go, my lord.
Let us see the photographs
But for
which
the
you have
hotel.
enclosed.
It was for the hotel. Lord.
Let's see the photographs which you have enclosed.
This one, my lord. Yeah, page 75, my lord.
Page
75.
75.
It was 153 feet, my lord.
My lord, this is not photograph. These are their design.
Yeah, where's your photographs?
From a field.
You are still on the proposed?
And that bridge is operational from the last 3 years. People are using it, my lord.
Where?
The
No. Mr. Sahiwala, where?
My lord.
Where is the photograph that it is infringing upon yours?
Yes, my lord. That drawing is here, not photograph.
Where is the how? This is still in the drawing, still in the question of proposed. We are at a particular stage where that particular bridge has already come in.
commission well 3 years back.
Then what remains? And if we are agreed for seek for compensation before the civil courts. Nothing is there.
No, that development, I'm what I'm asking, my lord. That footbridge is here. My lord, only
Then, if the footbridge has already happened, then where is the question of
No.
interfering?
Only, my lord, this long staircase, my lord, we wanted, my lord, that could be. Now they have dismantled the staircase. Now they have made some different design and they are constructing.
So now are you affected?
My lord, the new, my lord, we don't know, my lord. With that, my lord, yes.
So as to enable the petitioner effectively utilize the frontage of
These
the total.
photographs
You
are-
want the frontage of
Photographs are there
153
in
feet.
my affidavit at 3621.
Page?
Page 10, 3621.
Ah. How is it
Oh.
affecting your road?
No, sorry, I'm sorry, my lord. No,
This photograph doesn't show anything.
not ours, I'm sorry. Anyway, now that has been, my lord, dismantled, now they are constructing in some other design, my lord. That is why, my lord, we want to move to each time. We may have to do it.
No. Either you withdraw or dismiss. Which one you want? Either of it.
No, that of the, my lord, then your office may say, my lord.
Dismiss.
My lord, my humble submission is this, that footbridge, not footbridge, my lord, the staircase for which, my lord, we are complaining, that has been already dismantled. So if a new construction is made, then we can approach it. With that,
that
my
is
lord,
better.
just
That is something more. Mr. G.N. Sahiwala, the learned counsel, senior counsel assisted by Mr. M. Sahiwala, and Mr. R. Thor, the learned counsel appearing on behalf of the
1, 2, and 3, my lord.
respondents numbers 1, 2, and 3. And Mr. Asbora appears for
4 and 5.
respondent numbers 4 and 5. The instant writ petition has been filed, but the petitioner being aggrieved by the proposed foot overbridge.
Footbridge, my lord.
Foot overbridge. You have stated overbridge. I didn't.
It's a footbridge, my lord. My lord, the bridge
The
just in
foot-
front of that curve.
I know that it is foot overbridge only.
Foot over bridge.
Foot overbridge. There, as regards the foot overbridge, which was proposed to be set out which was proposed to be built and was likely to interfere with the frontage of the petitioner's plot of land. The learned counsel, Mr. R. Thor, appearing on behalf of the respondent numbers 1, 2, and 3, submitted that the said foot overbridge have already been commissioned
Commissioned on 14/2/2021.
on 14/2/2021.
21, my lord.
21. In the learned counsel further submits that in the meantime, the learned counsel for the petitioner submits that in the meantime, there has been certain demolition of the said bridge,
Staircase, my lord.
of the staircase, have been demolition of a portion of the staircase of the said bridge. He therefore submits that in view of certain subsequent events coming into light, the petitioner would not press the instant writ petition. But in the eventuality the petitioner is affected, the withdrawal of the instant petition shall not affect the petitioner to approach the appropriate forum. Taking into account the said submission, this court therefore closes the instant writ petition. It is, however, observed that the withdrawal of the instant writ petition shall not preclude the petitioner to approach the appropriate forum if the petitioner is otherwise aggrieved
But
with the subsequent course of actions
My lord.
taken by the respondent.
At number 3,
Yes, Mr. Raman.
Non-payment of contractual bill, your lord.
Who is not paying? Yes, Mr. Dhar.
PTC matter, my lord.
BTC.
PTC, my lord.
Yes.
let me get the instruction, my lord.
We are still in the stage of instructions. In the year 2021, the matter was to be listed after 3 weeks. Matter is of 2021. Then non-payment of contractual bills. In how do you take care of all those things?
My lord,
There is some order, no?
there's some order. Subsequently, there is a committee. If farm has been appointed, they make all farm has been appointed for all the inspection of the whether these are all the work has been done or not. Ultimately, the report comes. If the work has been done, my lord, we pay accordingly. My lord.
Where does he have to approach?
No, he doesn't have to approach. We already made an investigation, my lord.
You have investigated his case?
My lord, that instruction I don't have it because there are more than 2,000.
There comes something important. Yes.
All this report is there, my lord. That report we are waiting. That
So you want to verify and then
verify
take
then
us.
pay, my lord.
Okay, you will verify.
Not-
And if you are working out that, you will pay within a period of 6 months.
Not
Heard Mr. A. Rahman, the learned counsel, appearing on behalf of the petitioner. Mr. S. Bora appears on behalf of
the PTC, my lord. Respondent number
respondent number
329.
3 to 9.
And I will
And
appear for my
Mr.
lord one, and my lord, I will appear for 7 even, my lord.
Eh?
My lord,
You are appearing for?
1 and 7. That 1 and 7, my lord.
Okay,
The
Mr. Ardhor appears for respondent number 1 and 7. And who about the State Finance Commission?
State Finance Commission.
If you can appear for Deputy Commissioner, why not them also?
No, my lord, this is not State Finance Commission. My lord, maybe this is Finance
Department, you should have been finance department.
Department, my lord.
Okay.
Our name is reflected.
Okay, yeah. Third, Mr. Ardhor appears for respondent number 1 and 7. Mr. A. Sulia appears for respondent number 2. Mr. S. Bora appears for the respondent number 3, 4, 5,
6, 8,
6, 8, and 9. The instant writ petition has been filed by the petitioner, being aggrieved by the inaction on the part of the respondent authorities in not releasing an amount of rupees 20 lakhs to which the petitioner claims to be entitled to on the basis of the work done in connection with the construction of CC block pavement road from Hatigor Market to Beharbari village under Hatigor VCDC under CD fund for the year 2016-17. The learned counsel for the petitioner further submitted that the respondent number 9 had conducted an inspection upon the successful completion of the work and prepared an inspection report with work completion certificate, utilization certificate, etc., certifying that the said construction work has been 100% completed as per the plan and estimate. In that regard, the respondent number 8 had also issued a letter dated 8/9/2017 to the respondent number 3 requesting for a fund along with the pro forma bill in respect of the said construction work successfully done by the petitioner. However, the said amount of rupees 20 lakhs have not been paid in spite of various representations made by the petitioner. Mr. As per the learned counsel appearing on behalf of the petition respondents submitted that on 15th of November 2021, the Principal Secretary, Boroland Territorial Council had issued an order to verify all such works by conducting comprehensive audit, finalize financial verification and physical verification wherever applicable against all contractual works in the government level, and further to complete the whole exercise in this regard within 6 months from the date of the issue of the said order dated 15th of November 2021. The learned counsel appearing for the respondent BTC further placed before this court the order dated 15th of November 2021, wherein it has been further mentioned that after verifying the same, if it is found that the claims are admissible and after following all established norms, the same shall be processed in accordance with law and as per the decisions contained in Tamser Ali and others versus the state of Assam and others reported in 2008, 4 GLT 1. Taking into account the said order dated 15th of November 2021, this court therefore disposes of the incident with petition with a direction upon the whom.
No, make it, let it be all the respondent, my lord, because I think,
Why will Mr. Dhar do any exercise?
no, BTC authorities, my lord. Respondent representing the BTC authorities.
Disposes of the incident with petition with a direction upon the respondents in the BTC department, the respondents of the Boroland Territorial Council to make necessary verifications, and upon such verification, if it is found that the petitioner have completed the work, the petitioner be paid his dues. The said exercise be completed within a period of 6 months from the date a certified copy of the instant order is served upon the respondent number 3.
Lordship 3.
3.
And the 4.
My lord, I am praying for some accommodation, my lord, for some time, my lord. My friend D. Nath is appearing in this matter. He's in court number 1. He's coming, my lord. After some time, my lord. Because I am not aware of this matter, my lord. Actually, what's the problem, my lord? Maybe in 5-10 minutes he'll come, my lord. He's in 1 lakh in court number 1.
Let me also know what is the case with the time span you are giving. So by that time, he may not be required also. Yes, Mr. Das, you are challenging an eviction.
But eviction, because the petitioner here is a construction company engaged in the construction and maintenance of roads. And for that purpose, he is required to have a hot mix plant in which the bitumen is mixed with the stone chip for laying on the road. and that is should be in the vicinity of the roads, in the radius of 50 kilometer and all that, because the temperature of 110 degrees is to be maintained. And for that purpose, my lord, he had implanted a hot mix plan. Incidentally, it appeared to be a government plan, but he had taken it on lease from a person who was in possession of the land. But ultimately, my lord, by now, the construction is complete.
Then nothing remains.
But my lord, maintenance part is remained.
So why do you need that hot mix plan for the maintenance?
Maintenance it is required.
So
Because
then, what right do you have in respect to the land? You
No,
see,
no,
Rule
no, I
16.
don't have any right. As such.
Then nothing remains. No right, nothing. What can I do?
But my lord,
This court can only enforce a right which you have.
but my lord, your lordship can take a my lord, equity matter also. It is
Absolutely,
that-
the equity I can take, but the things of equity has to be on the basis of some right and the corresponding duty.
corresponding duty is the
Corresponding, is it a duty for them to kick you out there?
No, it is not. It is not. Normally, it is to be in the vicinity of the road under construction.
Understood, but your construction is over, nothing survives.
No, but the maintenance part is there.
Understood.
It is-
Maintenance
it is-
is what?
Maintenance of those roads, defect part and the maintenance, defect liability. Your lordship.
But can you have a right over the land on the basis of that, on the basis of that particular, you want it, you can very well ask it from your persons out there from the,
No, we will vacate it, my lord, after completion of the court.
completion is when? Completion you have already done.
Completion is done.
When is the maintenance period ending?
Maintenance period, it takes about 5 years. But
Huh?
it is under the contract itself.
So are you paying your dues to the government?
Under the contract itself.
Then are you paying to the government anything? Because it is after all government land. Take it on lease from the government. Otherwise, how can it have you have a right upon a land belonging to somebody else?
We had, my lord, 5 construction works, and of course, my lord, about maximum has been completed and maintenance work is also completed. About 2-3 remains. At page 51, 51, I had 5, my lord, A, B, C, D, E. 54 was.
Yes, wait, 6 minutes is over. Mr. Das, just 5 minutes you wait if I can. Otherwise,
My lord,
I'll-
I have an instruction. Just taking it.
wait, let your person come. You have only instructions, you have no, otherwise the authority. Yes.
Pipe.
Yes, Mr. Roy Chaudhary.
May it be, my lord, here the president is challenging a no confidence motion.
You're challenging a no confidence motion of a matter of 2021.
My lord, your lordship may just look into the last order.
Okay,
Because,
what happened? You got to stay.
No, my lord,
Then what remains?
because 5 years is there, my period was for 5 years. I take your lordship to trouble your lordship at page 24. I was elected on 15/12/2018. So 5 years is 23 December.
So we are in the fag end.
Again.
Only
My
3-4
lord,
months
I-
are left.
My lord, with all humility, I can only place, my lord, that whatever has been done against me, your lordship will find that, my lord, is not that me to say the provisions of law as laid down by this court, your lordship. is
Why you agree with the resolution?
Not only the resolution, the order passed where he had said the vice president to be taken over because I have been removed from the post.
You were the vice president?
No, I was the president.
Okay, where is that?
That page 41. Last paragraph. Your Lordship allows me to chronologically place the fact, my Lord. Your Lordship will find that you heard the rule, my Lord, it has been considered.
Yes, you tendered your resignation.
My Lord, Your Lordship, again, there is a provision in the law. After I tender my resignation, within 15 days, I can withdraw my resignation. That will not be given effect before 15 days.
When did you withdraw?
My Lord, before 15 days, my Lord, that is at page.
That was page 39.
39.
Okay. Now I want to resume my duty as the president of Twente, and as such, under the aforesaid provision, Your Honor may be kind enough to allow me. Due to personal, I had resigned from the post of Imam, and my resignation was duly accepted by the president on the basis of the further verification.
And it was received, and my Lord, Your Lordship, left-hand side, Your Lordship has found it, that they have received it. And my Lord, the main contention was there, my Lord, the 15 days period, because the notice was sent to the secretary. Then, my Lord, the provision lays down that it should be from the notice to the president, 15 days will be counted. My Lord, and Your Lordship is well aware and did not place, only to assist your court, this court, my Lord, that full bench has said that the requirement under the law is mandatory. So, my Lord, now the division bench has subsequently referred to in 2022 also, has said that notice is from the date when it comes to the notice of the president. And my Lord, the document says that Your Lordship may just turn to page 27.
Page
27.
Okay, to the president on 15/9/2021.
My Lord, Your Lordship, second paragraph. That, Madam, on 7/9/21, the Xerox copy of the petition stated above handed over to the president to put up the file with the note. It was given on 7/9/21, and my Lord, the date given to Anchalik Panchayat president is on 15/9. Your Lordship has got it. The letter was given on 15/9. Notice came to me on 7/9/21. So this notice, they themselves admit that it is prior to 15 days.
No, it has been mentioned that he has been writing that madam on
It came to my
7/9/2021,
notice.
the Xerox copy of the petition as stated above
Well,
was handed over to the president.
on 7/9.
Yes.
7/9, then 15/9, it was given to President Anchalik Panchayat. It should be after 15 days. So it is within 15 days, my Lord, they have done it. It was
15
given
days,
from the date of notice when it comes to my notice.
then
Then from there, 15 days will be counted.
to what period?
So till from the date when I received my notice, from that day till next 15 days,
For what?
that period will be given. That thereafter they will send it to the President Anchalik Panchayat. That is there, my Lord. If you not allow me to look this, my Lord.
Here if you see
52,
page annex
15 my Lord.
section 15,
15(2).
yeah. Every president shall be deemed to have vacated his office when a resolution expressing demand. Such a meeting shall be specifically convened by the secretary with the approval of the president of the year. Such meeting shall be presided over by the president when if the motion is against the president. In such a meeting is not convened within a period of 15 days from the date of receipt of the notice. The secretary of the town panchayat shall within 3 days. Yes. Therefore, this letter is written to the president.
President Anchalik Panchayat. This is not to me. This is to Anchalik Panchayat.
Okay. Who has written? The secretary.
Secretary. And if they have said that,
So you are saying that on 7/9, the letter was written to you, to the president, and within 8 days, they have the secretary has written to the Anchalik Panchayat. And on the basis of that, the meeting was called.
and my Lord, I have given my Lord to judgment. My Lord.
Not necessary. Yes,
My lord,
you set aside.
my lord, legal, as per legal provision, my senior colleague is correct, my lord.
Then what is left?
Yes, my lord.
We set aside that. But what about the
Resignation 14(2), my Lord. 14(2).
Deputy Commissioner is the authority.
where is that?
I will.
14/2. When did you resign?
My Lord,
Withdrawal is on 7/10.
7.
It was received on 7/10. Okay. 7-9. What is this?
My lord, I resigned on 28/9/21.
28/9/2021.
And
Okay.
before on 7/10, my lord,
You tendered your resignation.
my lord,
This is done under 14.2.
14/2, my lord.
14.2. Every resignation under subsection 1 shall take effect on expiry of 15 days from the date of receipt by the authority, unless within this period of he withdraws such resignation by writing under his hand addressed to the deputy commissioner in case of a president of so and so. Every president shall vacate office. Heard, Mr. We allow it.
My lord.
Heard, Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. S. What about the others?
Others, my lord, they don't appear, my lord, from the day.
The notice has been sent.
My lord, notice.
Heard, and Mr. S. Dotto appears on behalf of the respondent number 1,
1, 2, 4,
4,
5, and 7.
5
And 7.
and 7. And Mr. S.R. Bolwa, you appear for the deputy commissioner?
For 3, my lord, yes.
S.R. Bolwa appears for the respondent number 3.
Right.
The case of the petitioner herein is that that on 31/8/2021, 9 members of the Majigam Gaon Panchayat, had submitted a requisition to the secretary of the said Gaon Panchayat for convening and arranging the special meeting for no confidence against the petitioner who was the president of Majigam Gaon Panchayat. Full stop. It appears from the record that on 7/9/2021, the said petition, the Xerox copy of the said requisition, was handed over to the petitioner, who was the president. At this stage, it is relevant to take note of that section 15(1) specifically mandates that in case such meeting is not convened within a period of 15 days from the date of receipt of the notice, the secretary 15(1) of the Assam Panchayat Act 1994 stipulates that that in case a meeting is not convened within a period of 15 days from the date of receipt of the notice, the secretary of the Gaon Panchayat shall within 3 days refer the matter to the president of the Panchayat concerned Anchalik Panchayat, who shall convene the meeting within 7 days from the date of receipt of the information from the secretary of the Gaon Panchayat and preside over such meeting. It is the specific case of the petitioner, as could be seen from our materials on record, that on 7/9/2021, the Xerox copy of the requisition, so made by the 9 members of the Gaon Panchayat in question, was handed over to the petitioner. However, before the expiry of 15 days, on 15/9/2021, the secretary of the Gaon Panchayat in question had written to the president of the North Karimganj Anchalik Panchayat, and on the basis thereof, a special meeting was held
On 28/9/21.
on 28/9/2021. Full stop. On that very day, now, was there any resolution passed?
My lord, at page 32.
Good stop. On that way, in the same meeting, it was resolved against the petitioner. Thereby, the no confidence motion was approved. It is relevant to further take note of that on the very day earlier to the meeting, special meeting being held, the petitioner submitted his resignation to the Deputy Commissioner Karimganj. And this aspect would be seen from a perusal of the minutes of the meeting of the special meeting of no confidence. It further appears from the records that on 7/10/2021, the petitioner withdrew the said resignation letter dated 28/9/2021. However, the same was not accepted, and the Deputy Commissioner Karimganj had passed an order on 8/10/2021, thereby approving the special resolution adopted in the special meeting on 28/9/2021 and accepting the resignation of the petitioner. The petitioner, therefore, being aggrieved, has approached this court under Article 226 of the Constitution. Mr. S. Dutta, the learned counsel, appearing on behalf of the official respondents, have placed on record the materials which led to the resolution being adopted on 28/9/2021, as well as also the records pertaining to the acceptance of the, we've done that? No.
Yes, ma'am.
Acceptance of the resignation?
Resignation, that part is not there, ma'am. This is the procedure of no confidence.
Of the no confidence motion. This court have heard the learned counsels for the parties and perused the materials on record. From a perusal of the records so produced by Mr. S. Dutta, it appears that a requisition was made by 9 members of the Gram Panchayat in question on 31/8/2021, which was received by the secretary of the said Gram Panchayat at 1:30 p.m. It further appears that there is a office note pertaining to no confidence, wherein the signature of the petitioner is there. In the said office note, it has been mentioned that the Xerox copy of the petition was received by the petitioner on 7/9/2021. The petitioner put an endorsement on 7/9/2021, asking the secretary of the Gaon Panchayat in question to wait, no, with the remark, inverted comma, please wait. Although the records so produced do not show.
That is the peon book, my lord. Before 7/9, 5 times attempted, but he was not found, my lord.
Although the record so produced does not contain the communication dated 15/9/2021 as enclosed as Annexure C to the petition, but from a perusal of the said document, it is apparent that the secretary of the Gaon Panchayat in question have categorically mentioned that on 7/9/2021, the president was served a Xerox copy of the requisition so made by 9 members as regards the special meeting of no confidence against the president. Now, if this court looks into the provisions of section 15(1) of the Act of the Assam Panchayat Act 1994, it will be apparent that a period of 15 days have been given from the date of receipt of the requisition to the president for taking action, for calling the for convening the special meeting for no confidence, as that is the mandate of law for known confidence. And upon the failure of the president to do so, the secretary would be within its jurisdiction to issue a letter to the Anchalik Panchayat, president of the Anchalik Panchayat, to take appropriate steps in the matter as per section 15(1) of the Act.
Within 3 days.
However, in the instant case, it is apparent that the secretary of the Gaon Panchayat in question have issued the letter to have issued a communication to the president of the North Karimganj Anchalik Panchayat on 15/9/2021. Thereby, the period of 15 days from the date of receipt of the requisition by the president was not over. It further appears that thereupon the Anchalik Panchayat, North Karimganj Anchalik Panchayat, took appropriate steps for calling of the meeting, special meeting, and the meeting was called on 28/9/2021. Prior to the said meeting, at 11:50 a.m., the president tendered his resignation to the deputy commissioner, which is reflected in the minutes of the special meeting held on 28/9/2021.
Minute is also there.
Okay. Are you denying
Yes,
that
yeah, no,
minutes?
no,
No.
no.
It is there,
Yes,
written
yes,
out.
yes.
The resolution thereupon was passed, taking into consideration the withdrawal, the resignation of the petitioner, and expressing no confidence upon the petitioner. It further appears from the record that on 7/10/2021, the petitioner withdrew his resignation, which was duly withdrew his resignation, thereby submitting a communication on 7/10/2021 itself to the Deputy Commissioner Karimganj. The various endorsements were made in the said communication. Appears that the said communication was received by the office of the Deputy Commissioner on 7/10/2021 itself. There has been no materials placed on record by the respondents to show otherwise. Be it as it may, the Deputy Commissioner had, by the order dated 8/10/2021, approved the resolution adopted in the special meeting on 28/9/2021, and had also accepted the resignation of the petitioner. As there is no denial to the fact that the resignation was not submitted on 7/10/2021, this court finds it relevant at this stage to refer to section 14(2) of the Assam Panchayat Act 1994, which categorically mandates that every resignation under subsection 1 of section 14 shall take effect on the expiry of 15 days from the date of receipt by the authority, unless within this period of 15 days he withdraws such resignation by writing under his hand addressed to the Deputy Commissioner. In the case of the President, and the President of the Gaon Panchayat in the case of the Vice President. Taking into account the same, as the resignation of the petitioner was on 28/9/2021, and his resignation and his withdrawal of the resignation was followed within a period of 8 days, 8 or 9?
9 days.
9 days. And his withdrawal of this resignation was prior to 15 days, as mandated under section 14(2) of the Act of the Assam Panchayat Act 1994. The Deputy Commissioner ought not to have received, ought not to have accepted his resignation. Full stop. In that view of the matter, taking into account that the special meeting held on 28/9/2021 is contrary to section 15(1) of the Assam Panchayat Act 1994, and the acceptance of the resignation on 8/10/2021 was also contrary to section 14(2) of the Act of 1994. This court therefore interferes with the order dated 8/10/2021, interferes with the special meeting, the resolution so adopted in the special meeting held on 28/9/2021, the order dated 8/10/2021, whereby the Deputy Commissioner accepted this resolution adopted on 28/9/2021, as well as the resignation of the petitioner. Accordingly, What else do you want? I've set aside then. Anything else?
My lord, allow me to, my lord, take back my chair.
Is he asking for that? Are you asking for that in your petition?
My lord, their fear is there.
So in consequence thereof, this court further directs
The respondent.
that the petitioner, that the respondents, the official respondents shall take appropriate steps so that the petitioner is in a position to discharge his functions as the president of the Gaon Panchayat in question. However, this court grants the liberty to the respondent or to the private respondents or the members of the Gaon Panchayat in question to take such steps as is available under the Act of 1994. Petitions. Records so produced is returned herewith. I, pending applications, if any, stands disposed. Yes, where is that Mr. Nath?
My lord, he's still there, but my lord, this matter I have gone through and I have just had a consult talk with him, my lord. The matter has become infructuous. I have the subsequent orders was passed, my lord. Eviction.
Yes, he comes with your infructuous.
Oh, my lord.
Yes.
Item number 4.
Yes, Mr. Nath.
Well, here the petitioner's grievance was that at that point of time he was doing some contract works, but those works are already over, and he has no right to remain in possession of a government khas land for installation of a hot mix plant. Now,
that I've understood. That, for that I have not waited for you. For that I would have otherwise dismissed it without.
I'm sorry.
I'm waiting for you for the purpose. That if for the purpose of maintenance and all, can't you give it to him on lease basis or something? We are not concerned from whom he has taken. Only for that purpose, which you normally do, as I could see in many constructions which are being made on the road. Not here, in the highway constructions which are being made. On the side, some lands are being given to those contractors. Now, you would be at your wisdom to take appropriate action. And that is why I asked, not for the other. He has no right, no quarrel with that proposition, he has no right. And after the contract is over, but for maintenance, if it is required, he may take appropriate steps with you so that you can take a call on that.
Yes, yes.
I think that is a win-win situation for both.
That can be the only situation, solution.
And that is the only equity. Mr. B.C. Das, the learned senior counsel, assisted by Mr. D.N. Bhattacharjee. And Mr. D. Nath appears on behalf of the learned senior government advocate, appears on behalf of the respondent state. Who appears for revenue? Are you there? Mr. A. Bhattacharjee appears for the Revenue and Disaster Management Department. The instant petition has been filed by the petitioner challenging the order of eviction dated 6/10/2021 issued by the Circle Officer, North Guwahati Revenue Circle, Amingaon, Guwahati. As well as for consequential reliefs on the basis of the said directions. A perusal of the materials on record would show that admittedly the petitioner is in possession of government land pertaining to dark number 116 of village Dirgheswari under Borgongsor, Muza.
Yes.
On account of, for the purpose of carrying out the various contractual works for road building, for road construction, the petitioner has used that particular land by taking a lease from a person who was otherwise in possession of that land. The learned senior counsel fairly submits that at present, for the petitioner fairly submits that at present, the construction works in question have been completed. However, the petitioner requires to keep the land for some time for the purpose of maintenance of the roads in question, inasmuch as in the land in question, the petitioner had installed a hot mix plant. And it is the requirement of the engineering specification that for using the bitumen, it has to have a particular temperature.
Yeah.
And as such, if the said land, the petitioner is evicted from the said land, it would cause a difficulty. It would not only cause a great amount of difficulty to the petitioner for carrying out his contractual work for the purpose of maintenance, but would also affect the public interest in as much as the land in question, in as much as maintaining, keeping the roads maintained is also in public interest. On the other hand, Mr. S. D. Nath, the learned senior government counsel, senior government advocate, submits that the petitioner has no right to remain in possession of the government land unless and until the government permits him to do so in terms with Rule 16 of the settlement rules. He therefore submits the question of interference with the said notice dated, what is that notice date? 39? 39, 2021. Huh?
6/10/21 is the order.
610.
Page 53.
Page
53.
53. Therefore, the question of interference with the order dated 6/10/2021 requires no interference. The learned senior government advocate further submitted that merely because of the fact that the petitioner has obtained a lease from a person who is otherwise not authorized would not give him any right to continue to remain in possession of the said land. Upon hearing the learned counsels for the parties and upon perusal of the materials on record, this court is of the opinion that a question of interference with the order dated 6/10/2021 does not arise in view of the fact that the petitioner does not have any right to continue to remain in a land, government land. Next. However, this court also finds it relevant to observe. No, however, be it as it may, this court, however, grants the liberty to the petitioner to approach the concerned respondent authorities and the respondent authorities, upon being approached by the petitioner, after duly taking note of the question pertaining to the public interest of maintaining the road, shall in its wisdom take such action as deemed fit. With the above the petition stands. That is the most.
Much obliged.
You take whatever you like.
Yes, yes, yes.
But they have contract with PW, and they are making respondents here this circle officer and the PC. If they need some space for having the maintenance work and their plan for the maintenance work, they have to take up the matter with the PWD that we will do for 5 years, next 5 years. But in the name of maintenance work, how they can just continue?
No. That is why I dismissed it.
Correct, Malad.
I have therefore asked them, they may approach you.
Approach, yeah.
And you may take,
Logical.
as per your wisdom, I would put the word wisdom.
Logical.
I am not imposing anything, no mandamus, nothing. You
Logical.
do whatever you feel like.
Malad.
But take into account if the maintenance is required, you may refer it even to the PWD and say the PWD.
Yes.
I may put a line also if you want that the petitioner is also at liberty to approach the
Contracting part.
Appropriate authority, your lordship.
the PWD
The contracting.
for allotting specific land for the purpose of maintenance.
If at all logical.
The petitioner further is also given the liberty to approach the Public Works Department of the Government of Assam for allotting some portion of land so that the petitioner can carry out its can maintain its hot mix plant for the purpose of maintenance of the road.
Logical. Of the works.
Eh?
Works in question.
PWD?
The works in question. Here 4 works he has done. Only for those works.
Oh, only
Not
for
not for everything here. Logic.
No. See, I have only given liberty
Logic.
to him.
Logic.
I am not directed even to consider. I've
Correct.
never. I only said that in your case, he will submit, and you, at your own wisdom, shall take due action.
Malad. Logic.
61 and 62.
Yes, Mr. Das, are you giving undertaking?
The undertaking, your lord.
Huh?
You reduce the undertaking.
I also thought about it because what happens otherwise, although there is no res judicata, there will be a res judicata upon them, but they may file an appeal.
Correct. Yes.
And the appeal will also be dismissed.
Yes.
They will go to the Supreme Court.
Correct. Same.
There you have to defend yourself,
Yes, your lord.
and that will take care of the interests.
Correct, your lord.
Heard both the petitions, huh? Same person, na?
Yes,
Why
sir.
both petitions?
Yes, your lord. Period is different, lord.
Huh?
Period is different.
Okay, heard Mr. Kane Chaudhary was here, na?
Yes, your lord.
I'll put his name.
Yes, your lord.
Heard Mr. Kane Chaudhary, the learned senior counsel, assisted by Mr. A. Das, the learned counsel appearing on behalf of the petitioners, and Mr. S. C. Kyle, the learned counsel appearing on behalf of the GST. Where is that order? Got it. Pursuant to both the petitions relate to the same question of law as to whether the petitioners would be entitled to the interest on the refunds under Section 11 BB of the Central Excise Act 1944. On 26/5, no, this very question have already been settled by the judgment by the division bench of this court in the case of Amalgamated Plantation Private Limited versus Union of India, reported in 2013 2 GLT 413, wherein it was observed that in respect to the refunds, wherein it was observed, it was held that Section 11BB of the Central Excise Act 1944 does not exclude claim of refund made in terms with the notification dated 8/7/1999. And therefore, the petitioner therein was held to be entitled under the provisions of the Central Excise Act 1955 and 1944 to interest on the excise duty refunded to them. As the same question is also involved herein, the learned counsel appearing on behalf of the GST has drawn the attention of an order passed by the division bench in the case of writ appeal number, in the case of Union of India versus Panparag India Limited, writ appeal 102/2022, wherein the division bench taking into account that an appeal has also been already prepared by the revenue before the Supreme Court, which have been registered and numbered as SLP number 016322/2018. Directed the appellant department to make payment of the interest on delayed refund to the respondent assessees within a period of 2 months from the date of the said order passed by the division bench. It was, however, made clear, observe, that the assessee therein shall furnish an undertaking that in case the revenue succeeds in the aforesaid SLP, the interest amount paid under the order of the division bench shall be reimbursed to the department. This aspect of the matter was earlier brought to the attention of this court by an order on 26/5/2023, wherein the counsel appearing on behalf of the petitioner sought for some accommodation so that the instructions could be obtained as to whether the petitioner herein would be inclined to give an undertaking in the manner which have been directed by the division bench in the case of Panparag Supra. Today, Mr. K. N. Chaudhary, the learned senior counsel, upon instructions from Mr. A. Das, submits that the petitioner is also willing to give an undertaking in the same manner to the effect that the assessee, that the petitioner is willing to reimburse the interest amount if paid pursuant to the orders passed by this court. In the eventuality, the SLP so filed before the Supreme Court is allowed in favor of the revenue. Taking into account the above, this court therefore disposes of both the petitions with a direction to the respondent authorities to pay, to disburse the amount of interest to which the petitioner would be entitled to on its refunds within a period of 2 months from the date of furnishing a certified copy of the instant order, along with an undertaking that the petitioner would reimburse the amount so paid as interest on the refunds if the revenue succeeds in SLP number 016322/2018. With the above, both petitions stands disposed. Yes, I'm done with the top of the list.
Item number 6 for motion.
My lord, this matter relates to non-payment of salary, and as there is some delay in filing the petition.
Yes, why did you seek for adjournment on the last occasion?
I seek time for producing some documents if the petitioner has to, so that there is that after 2018 that there is some communication. But the
There's some delay, na?
Yes, my lord.
Then what happened? Nothing. You have not done anything. Withdraw, dismiss, which one?
My lord, may I pray, my lord, I may be allowed to withdraw with liberty to approach the authorities, my lord.
Yes. That looks. What do you say? That's it. Heard Mr. A.K. Gupta, the learned counsel appearing on behalf of the petitioner, Ms. D. Musari, the learned counsel appears on behalf of the Secondary Education Department. The learned counsel submits that the instant claim so made the instant writ petition has been filed seeking a direction for release of the area salary of the petitioner with effect from 1/1/2013 to 11/12/2013 with interest.
Wife of the
Releasing the area salary of the wife of the petitioner with effect from 1/1/2013 to 11/12/2013 with interest. The learned counsel for the petitioner submits that he has instructions to withdraw the instant matter as the petitioner proposes to approach the concerned respondent authorities for redressal of his grievances. Taking into account the same, the instant writ petition stands closed. The petitioner would be at liberty to approach the authorities if so advised.
7.
Yes,
why didn't you appear on the last occasion?
I was not keeping well, my lord, and I was not keeping well.
Fantastic. Now tell me, now you are better?
Yes, my lord.
Okay.
Today also
What are you asking for?
This matter relates to pensionary benefit matter. The petitioner was the wife of this person who was working under Assam Rifle. Actually, he was married for second time with the petitioner after death of the first wife. And then he subsequently threw out this petitioner from his house. And
petitioner is?
Second time married. Secondly married, but after death of the first wife, she was married.
Okay. The petitioner married the whom?
This is person, he was working under Assam Rifle.
Petitioner is Runumoni Chaudhary.
Yes, sir.
Wife of Uttam Kolita.
Uttam Kolita was working under Assam Rifle.
Earlier, Uttam Kolita was married to somebody else.
Yes, he was
and that somebody else died.
Died. After that marriage.
After that, the petitioner married Uttam Kolita.
Yes,
now, Uttam Kolita died.
Uttam Kolita voluntary retirement was taken up. After getting some days pension, he was died. But before that, another incident was happened. This petitioner was thrown out from his house. This petitioner, that the second wife, was thrown out from his house by the deceased person. And she filed a maintenance case before the trial court. In that case, trial court has given direction in favor of the petitioner. In between, that person, deceased person, has married for third time.
Okay. Without a divorce?
Without a divorce. Then, after death of this deceased person, both wives approached the Assam Rifle for getting pensionary benefit. And Assam from the concerned department says that you submit next of kin certificate. For that required Gambura's a certificate, but Gambura has denied that I will not give anyone.
Both of them.
both of them.
Then
Because there was a conflict between both the wife. Now, thing is that the petitioner approached the Assam Rifles on 2020 itself, and also physically went to the office also, but nothing was done. That is the current position.
yes, Mr. S.S. Roy.
Lordship, I have to take the instruction. Here, Lordship, the death certificate was not annexed anywhere. The
My
first
lord,
wife death
that's why I have annexed the
in the pension
with the third wife.
Huh?
Death certificate was in the hand of third wife because the third wife actually lived with the person in at the last stage of his life. And another my lord,
Wouldn't
another-
the central civil service pension rules apply?
It will apply, Lordship. The second wife
Then
is
as per 54/7, both will get.
both will get, Lordship, but here, Lordship, what I have seen, Lordship, from the PPO order, Lordship,
Where
the
is the
first
PPO?
wife,
Annexer 1,
13, page 13, Lordship.
Annexer 1.
The first wife name was there, Lordship. It has not been
Page 13.
13, Lordship. But 9, clause 9,
Where? Serial number?
clause 9.
9. Clause 9.
Deepa
Total
clause-
length of service?
Voluntary return.
Till the voluntary retirement was taken. I have mentioned this fact
2019.
in my environment also.
Where is that? Deepa Kolita.
Yes,
Yes, my
Lordship.
lord. This fact is I have also mentioned in my environment also.
Rest
But
of-
they will also get this one, Mr. Udipta Kolita.
They're, I think they now become major. 90s,
Municipal actually
No. As per the CCS rules, is 25.
Lordship.
It's not 19.
Hmm.
This person will get Udipta Kolita. And Mr. Counsel, why haven't you make Udipta Kolita a
Not
party?
a party.
my lord.
Then file it properly. This person will get it. Do you have the CCS rules or are you sticking on Assam pension rules?
I have to.
Then you don't know what is you are filing. Isn't it? Because that day I saw that particular provision.
Lordship.
A person is entitled to 25 years.
Lordship.
What are CCS rules? Huh? CCS pension rules. See,
Sub rule 7.
no, this is there. He will get it. But here, who will be shall be eligible? An unmarried son or unmarried daughter or so and so, except a disabled heir, shall become eligible for family from the date he or she gets married. The family pension of the son on remand in the explanation is so and so remand before that. Somewhere I've seen it. 25. You have it? That day I saw that book. Is it? It up on. 50 years rule. Because yesterday Mr. Parasar produced it to me day before. So much of it. Hello. Anak ko na yun. থাকিব লাগে না পেনশন কোট এখন the definition of family anak ko. I'm coming in 5 minutes.
I'm take. হকটকে কিতাপটো নাছিলে Rule 50, Lordship, Rule 50, Clause 7 in CCS pension.
Now, who will be the family and then pension shall be initially payable to the minor children mentioned in 2 and 3 of the year in the order set out in clause 3 and rule 8. Until the last minor child attains the age of 25 years.
No.
So under such circumstances, how can you maintain it without making him a party?
Both of them, that may be allowed.
Is Krishna Kolita and
Krishna
Kolita would be more than 25.
She already married.
Married.
But Udipta Kolita,
20 years.
he can't be married now. He's not 25. So you have to make him a party.
No.
My lord.
Withdraw and file it refresh. এখন কি এখন কি okay heard Mr.
Yes, Lord.
So and so the learned counsel appearing on behalf of S. Roy, the learned counsel for the petitioner, Mr.
All the rest.
S.S. Roy appearing on behalf of the respondent numbers.
All the rest.
No, you can't be.
Lordship.
Respondent number 1 to 5.
1 to 5.
From a perusal of annexure 1, it reveals that the husband of the petitioner left behind his son, Mr. Udipta Kolita, who, as per the pension CCS pension rule, 1972, would also be entitled to pension, the family pension. However, the said Udipta Kolita had not been made a party. Considering the above, the petitioner therefore submits that he may be permitted to withdraw the instant writ petition and refile if so advised. Taking into account the instant writ petition stands closed on withdrawal, however, liberty is given to the petitioner to refile if so advised. But I think you contact out there. I think that son may be getting because his name
The
is there.
part is there, pilot 2001. So 23, he will be 22,
That is what he may be getting it. Just find out.
my lord.
Item 9.
May it please.
Yes, Mr. Bhuya.
My lord, the petitioner before lordship retired on 31/12/2021. Provisional pension not been paid, pension not been paid, the gratuity is not been released.
Why?
This is because of the fact that I have stated in paragraph 32 of the petition, wherein, my lord, for the post of the principal, there was the tag of war between me and the respondent number 5, who is the present principal. Now, thereafter, my lord, I was the in charge principal. I contested for the particular selection process. I appeared. He was successful. So after getting appointment, my lord, in the meantime, I was on medical leave. When I was in charge principal, my lord, some money of that particular higher secondary school was with me. And thereafter, after my return, I tried to refund that particular money because the charge was taken by him unilaterally from the inspector of school. So I tried to return, but there was specific instruction not to take that money. So I approached the inspector of schools for the payment, to hand over the cash that was with me at the time when I was in charge. Inspector of schools directed me to pay by way of a check. Check was my personal check. It was not been accepted on the dictation of the principal, respondent number 5. Now again, I went to the inspector of school. He said that you make a draft and deposit it. I went to deposit the draft. He doesn't accept it.
These are all verbal.
My lord, it's on written. Everything is there.
No, inspector asking you to.
Yes, it's been verbal. And thereafter, my lord, what he did, my lord, the respondent of our laws and FIR against me, my lord, with regard to misappropriation, in which charge sheet has been filed, my lord. Cognizance was taken, charges were framed. Even this particular respondent number 5 has been examined as PW1. He's the informant. Now, thereafter, this petitioner has been advised that here is a case wherein the public servant, a case has been registered and cognizance has been taken without the sanction. So, belatedly, a revision application was prepared in the sessions with a delay condonation petition. Now, that delay condonation petition was heard at length, and thereafter, this delay was condoned. Against that delay, the principal again came to before this honorable court and obtained a stay order. That delay condonation was heard, my lord, this revision again in the High Court was heard and dismissed. Ultimately, the matter went to the revisional court, my lord. The revisional court on the last occasion, my lord, it was last week, state the matter, call for the record. That is the status. So, my lord, as for the pension rule, provisional pension, my lord, I am entitled to it. Principal doesn't have any authority to withhold under Rule 21. That's been the law. So now, in the name of that particular fund, he is not issuing the no liability certificate and the audit, my lord, my salary and everything, because he is the principal. He has to submit that. It's not been done. If your lordship goes to the last 3 documents, kindly see, my lord, at page 111, my lord. It's been from the authority concerned inspector of schools at page 111, my lord. With reference to the subject about, I have the honor to inform you that as the head of institution, you must be aware of about the procedure for submitting pension papers in respect of retired teachers of your school.
When did you retire?
31/12/2021. No departmental proceeding is there.
No departmental proceeding?
No, my.
But there is a criminal case.
Yes, that.
Hard, Mr. And what is the amount of misappropriation?
my lord, according to them, my lord, it is 23,330 or something like that, my lord. According to me, it is something 9,000 something. That's Saraswati Puja, my lord.
No, we are not concerned on
Yes,
that.
yes.
Heard Mr. A.K. Bhuiyan, the learned counsel appearing on behalf of the petitioner. Ms. H.D. Musari appears for the respondent number 1, 2,
And 4.
4. So Mr. S.R. Burwa appears for the respondent number 7. Accountant General? None. None appears for the Accountant General on call. Issue notice making it returnable on 24th of July 2023. As the respondent numbers 1, 2, 4, and 7 are duly represented by the respective councils, extra copies of the petition be served upon them by 31st of May 2023. As regards the respondent number 3, taking into account that there are standing counsels for the Office of the Accountant General, Assam, the petitioner is given the liberty to serve a copy of the petition by 31st of May upon a standing counsel of the Office of the Accountant General, Assam. As regards the respondent number 5 and 6, steps be taken by way of registered as well as usual by 31/5/2023. The petitioner further is also directed to take steps upon the respondent number 5 by way of the state, routed through the registry of the court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner, after rendering service, retired on 31/12/2021. 21. It has been alleged that on account of the malafide actions of the respondent number 5, the petitioner's pension papers have not been processed, as well as also the provisional pension which the petitioner is otherwise entitled to under Rule 22 of the Assam Service Pension Rules 1969, read with the office memorandum dated, what is that date? Office memorandum dated 21/6/2012. It is therefore the submission of the learned counsel appearing on behalf of the petitioner that for no fault of the petitioner there has been a criminal proceedings initiated against the petitioner, which is however subject to certain proceedings before the revisional court. Be that as it may, it is the specific case of the petitioner that the petitioner is otherwise entitled to the provisional pension in terms of Rule 22, read with the Rule 22 of the Rules of 1969, read with the Office Memorandum dated 21/6/2012. Upon hearing the learned counsel, this court therefore directs the respondents in the secondary education department to apprise the respondents in the secondary education department, as well as the respondent number 5 and 6, to apprise this court as regards the status of the pension proposal of the petitioner and as to why the provisional pension has not yet been paid. This court further directs the respondent number 5 and 6, who is going to pay the provisional pension? It is you. Further directs the respondent number 2 to forthwith take steps for release of the provisional pension to the petitioner upon a certified copy of the instant order being served upon the respondent number 2.
Apply.
Item 10.
My lord, this non-liability certificate and the audit will be required for granting me provisional consent, which he fulfilled in fact.
Don't worry. This order has been passed. They will take care. You submit the certified copy.
Definitely.
Yes, Mr. Khatonia, we see you on this side.
Yes, ma'am.
Why?
But earlier, I have withdrawn this petition, my lord, because I have not annexed certain documents. This is regarding suspension. My withdrawal order at page 41, my lord.
Okay. The requirement of bringing on record petition and materials by amendment. Yes, then.
My lord, my suspension order at page 20. My
suspension?
Suspension, my lord. Page 20. With reference to the subject and letter number so and so, you are hereby placed under suspension with immediate effect from 5th July 2014 until further order and formal proceedings are being drawn up against you. So, my lord,
you are quashing the suspension order of 2014.
yes, my lord.
What has happened to the departmental proceedings?
No, my lord, nothing has been initiated against me, my lord.
Why did you withdraw last time?
Because my lord, in advertise I could not annex the bail order and my representation, earlier representation. But bail
When
order
did you
is
submit your representation?
Representation is at page, my lord, page 33. That is submitted on 21st July 2014, my lord.
July
2014.
Can you be suspended under? You are not suspended under the provisions of the 64 rules. Are you? You are temporary appointee.
No, I'm not temporary, my lord.
Where are you permanent?
My appointment order is at my lord. Initial appointment order is at my lord is at 16.
Date?
Page 16. The following incumbent who have been temporarily appointed as laboratory technician.
That is temporary.
Against hereby regularized, my lord. Thereafter, by this order,
are hereby regularized with effect from the date of joining against vacant post. So on 12th of February, we are regularized.
Yes, my lord.
Then where is the order of suspension?
Order of suspension, my lord, page 20.
You are placed under suspension until any formal proceedings are drawn up. Why?
Because of my
on
name.
PS case.
Yes, my lord. In a criminal case, my
You
lord.
are
In fact,
alleged of murdering somebody.
Yes, my lord. That is the allegation, my lord. In fact, my lord, kindly see the bail order, my lord. See the bail petition filed on so and so, accused so and so.
The perusal of the CG and accused, I found no
sufficient ground to detain the accused for more than search sheet was submitted, my lord.
Then charge sheet, your name is there.
My name is there, my lord. In fact, I have appeared before the trial court also, my lord. And I was given.
And what has happened till now? It's a long pending matter.
Yes.
Then?
Subsequently, I represented before the authority on my lord 21st of July.
Are you getting your subsistence allowance?
Subsistence allowance, my lord.
Because it seems from the last 9 years, you are only the last representation is of the year 2014.
Yes, no, thereafter there is a representation in the year that here is not visible in this, legible in this.
Prayer for 2023.
Yes. Subsequently, in the year 2023 also, I have.
So you have woken up after 9 years after the withdrawal of the petition.
After withdrawal of the petition, I have submitted the face representation, madam.
So
earlier it was there, madam.
Earlier it was there in 2014.
After 14 also, I have the annex 10, page 35. Though date is not legible, madam, that representation is there, madam.
Date is not legible means there is no date itself.
Madam, in the here, madam, there is a date, madam. Yours faithfully. There is a date, madam, but it is not legible. But this is
court. Even
after,
I think using a microscope also you won't see the date.
Yes, after 2014, madam, this is another representation I have submitted. And thereafter, my lord, the last representation in the month of July, February, my lord.
What is this? This is a representation by somebody else.
Yes, my lord.
This is not by you.
Yes,
somebody else has said.
Yes, my lord.
Then
In any case, my lord, the authority is aware of that, my lord.
Then
Regarding my bail, my lord, I was not in custody. That
what happened after 15 to?
15 to nothing, my lord.
Are they reviewing your suspension order?
No, my lord.
I heard Mr. N.J. Khatuniya, the learned counsel, appearing on behalf of the petitioner. Miss, madam,
Yes, compelled.
to appears for the respondent number 1,
2,
2,
4 and 5.
huh?
4 and 5.
4 and 5. Miss
I am for
Deborah appears on behalf of the respondent number 3. Issue notice making it returnable on 24th of June 2023. Suspension matter. Early disposal. As the respondents are duly represented, extra copies of the petitions be served upon the learned counsels during the course of the day. The case of the petitioner herein is that the petitioner was suspended. The petitioner was suspended by an order dated 7/7/2014 on the ground that the petitioner was arrested in connection with Dispute PS case number 127/2009, registered under section 302 IPC. The learned counsel for the petitioner has drawn the attention that on 31/5/2014, he had been already released on bail, and thereupon the petitioner had submitted a representation to the authorities concerned for revocation of the suspension order as far back as on 30/7/2014. It is further seen from the records that the charge sheet has also been submitted in respect to Dispute PS case number
127.
127/2009 on 21/11/2009. However, it doesn't appear what is the present state in respect to the said criminal proceedings. Be that as it may, the petitioner continues to remain under suspension, and it is the specific submission of the learned counsel for the petitioner that till date no departmental proceedings have been initiated against the petition. The learned counsel for the petitioner therefore submits that that this is a pure case of a protracted suspension, and there has been no review or any reason to order passed thereafter by the respondent authorities, although they are required to do so as per the law declared by the Supreme Court. The learned counsel appearing on behalf of the respondent number
1, 2, 4 and 5.
1, 2, 4 and 5 shall apprise this court as regards as to what steps have been taken by the state authorities, but in respect to the suspension of the petitioner, and as to whether the said suspension have been reviewed periodically, which is required as per the law laid down by the Supreme Court.
11.
Yes, Mr. Pathak.
My lord, this is against the impugned dismissal from service, my lord. The incident that had happened, my lord, was that at the time of enrollment, while filling up the enrollment form, the declaration relating to, my lord, tendency of criminal cases was required to be made, in which the petitioner said none. But then,
You did not declare it.
my lord, the difficulty was that he was arrested, my lord, in a Bihar liquor case, my lord. Immediately after this Bihar prohibition of liquor came in 2017, he was arrested. But then there was no proceeding in the case. In 2021, when I filled up the form, my lord, I was not aware if any charge sheet has been filed against me. Then a show cause notice came to me, my lord, that you have made a false declaration. In fact, I have a certificate from the concerned police office also about my character that there is no case pending. But then in 2022, my lord, the charges are framed. At that point of time, I say that give me some time to prove my innocence. But then, without holding any inquiry, my lord, I was dismissed from service.
On the ground that you have given false statement.
And subsequently, I have been accused. I think the guidelines, my lord, as to what is to be done in this.
You have been acquitted. Where is the order of acquittal?
Acquittal is the last page, my lord. Sorry,
Let us
last
see
annexure.
page 25. Does it say anything about acquittal?
25, my lord, there's probably some error in my lord fixing the page numbers, my lord.
Huh?
Should be page 24, my lord. Some error by the clerk, my lord. The last page is actually page 24.
What is your name?
Vijay Chaudhary. Vijay Kumar. Vijay Chaudhary.
So you have been now acquitted.
Acquitted.
On the ground?
That the charges were wrongly framed. There was insufficiency in the investigation itself.
Now, what was the requirement here?
The requirement, my lord, says that there is a column, my lord. In fact, the enrollment
Where?
form has to be seen from the records, my lord. There is a column
You
12,
were
my lord,
enrolled in the Assam Rifles against the vacancy of Bihar State and furnished the character certificate. All the time, a verification certificate report received from the office of the Imam. When were you appointed?
2021, my lord. April 2021.
So as on that, there was a case pending.
Yes.
My lord.
You knew about it?
Yes.
Because this order was passed sometime around 2023 in respect to
23, my lord, I
Bagala
got it.
PSK. Where was the charge sheet submitted?
Charge sheet, my lord, was submitted. If your lordship sees the
Charge
judgment.
sheet submitted in 2017.
My lord.
It is there at page annexure
Annex
5,
five, the
page
first
19. Then date of framing of the charge, you knew it on 8/2/2022.
My lord. That was after my appointment, my lord. That was my case, my lord.
So obviously you knew about the after the charge sheet, you must have attended somewhere
No, my lord.
before the authorities.
Only
After the
when
charge,
the charges were framed, my lord, I was called. And that point of time, I immediately came back.
are you saying that only on the basis of the charges were framed you had gone, not prior to that, before the
My
court?
lord, normally what happens is that after charges are framed, the person is arrested. If he is released on bail, subsequently, a charge sheet is subsequently submitted by the police officer. Then the court again issues summons to the person concerned.
So you didn't receive the summons till then?
Then I appeared, and in 2022 only, when my lord, the charges were framed, I got to
When
know
did
that
you appear? First appear after the notice, the charge sheet was filed.
That's the entire record I have to get, my lord.
Then
But then
you are not
apparently
clear on
the
that.
judgment says that only on 2022 the charges were framed, my lord.
I understand, but this court also knows that I think in Bihar also the same CRPC applies. Then the charge sheet has to, once the charge sheet is filed, either a warrant or a charge summons will be issued to you. Then you must have appeared there. And there were many people out there along with you.
Yes. There was another co-accused.
Then, anyway. So you did not, what was the requirement? What was to be inserted therein?
Yes or no, my lord. There's the column yes or no, my lord.
What is yes or no?
It is column 12 which says, my lord, whether any criminal case is pending or you were earlier convicted in any criminal case.
Okay. The criminal case is pending means FIR would not be a criminal case.
Yes. My lord, there are different views on it, my lord. Unless charges are framed also, my lord, sometimes
FIR would not be a criminal case.
yes, once it is registered, it is a criminal case. Once the FIR is
Then
registered, it is a criminal case.
you knew about it. You were arrested in respect to that in the year 2017.
My lord. But then the law, my lord, subsequently as elucidated by the Appellate Court, it says that you have to now classify as to what are the seriousness of the offense, nature of the offense, the time at which the offense was committed, what was the age of the accused at that particular point of time. All these factors, my lord, have to be taken into consideration. If it is a serious crime of like murder or any other case, my lord, in those cases, yes, no acceptance.
We are not concerned with the seriousness of the crime. We are concerned about non-disclosure of the information. Yes, there are many cases. These are, after all, it is in the disciplinary forces. Discipline forces. Wouldn't that come within it? Anyway,
I think the law is late on, my lord,
at
in
least
of
you are
that case,
entitled to a notice. Heard Mr. B. Pathak, the learned counsel, appearing on behalf of the petitioner. Mr. S. S. Roy appears for the respondent numbers.
All the respondents.
Of respondent numbers 1 to 4. Issue notice making it returnable. You have to file your affidavit now.
Yes.
Issue notice making it returnable on 26th of July 2023. As the respondent numbers 1 to 4 are duly represented, extra copies of the petition be served upon him during the course of the day. The case of the petitioner herein is that the petitioner was that the case of the petitioner herein is that by an order dated 31/3/2022, without carrying out any departmental inquiry, the responding authorities have dismissed the petitioner on the ground of submitting false information at the time of enrollment. The respondents are directed to file their affidavit by 24th of July 2023.
Item 63 from supplementary list.
Yes, madam. What did you find out? Wow. How can you take care of his leg?
Lordship, authorities requested to grant 2 weeks time to take a decision on this matter, Lordship.
Okay, we stay then.
Lordship.
Mr. K. Bhattacharjee, the learned counsel, appearing on behalf of the petitioner. Ms. B. Devi appears on behalf of the respondent numbers 1 to 5. 1 to 5, 6, 7, 1 to 7. Issue notice making it returnable on when?
Lordship,
We have it on
15.
Can we have it on 23rd of June? 23rd of June? Issue notice making it returnable on 23rd of June 2023. As the respondents are duly represented by Ms. B. Sharma. However, B. Sharma Lihude, B. Divino. Extra copies of the petition be served upon her by today, during the course of the day. The petitioner herein is aggrieved by the order of transfer dated 15/5/2023, whereby the petitioner have been transferred from where?
My lord, here.
IOC.
Page?
Your lordship will annex 6, my lord.
Page?
Page, my lord, 20.
Whereby the petitioner have been transferred from where to where?
Serial number 4, my lord. From Nunmati to Dibrugarh.
Room number?
IOC, Lordship.
IOC 4,
IOC
my lord.
Nunmati.
Where?
Serial number 4, my lord. Bottom, my lord. Disclosure of the application submitted.
Of the application of Toronto, whereby the petitioner have, what is the name of the petitioner?
Bipul Kulka, my lord.
Whereby
Bipul
the
Talukdar.
petitioner have been transferred from OPS Nunmati to BPCL Dibrugarh.
Yes, my lord.
It is the case of the petitioner that the petitioner Subsequent thereto, the petitioner submitted a representation. And by then order dated 15/5/2023, the Assistant Commandant CISF Unit OPS Nunmanti observed that the petitioner would be relieved from his present place of posting on 31/5/2023. It is under such circumstances that the petitioner has approached this court under Article 2 to 6 of the Constitution. It is a specific case of the petitioner that the petitioner has 60% disability and for which the medical authority Kamrup Metro had issued a certificate dated 1/10/2013 stating inter alia that the petitioner is a case of locomotor disability. He has amputation of the left leg.
Right.
Of LL means what? Page 13, you see? Amputation of LT, BK. What is it?
30.
Left leg?
Well, this is page 13.
What is that?
But that is, this is the left, right leg, my lord.
Right.
Here, column 6, my lord, 60% disabled figure, 60% disabled on to his right leg. That small
diagnosis is
C,
for
ABC.
amputation of LT, LL, bracket BK. It has also been mentioned that he has 60% permanent disability in relation to his right leg. And as such, he is a person included under the Right to Persons with Disability Act 2016. It further appears from Annexure 11, 10 and 11 of the writ petition that the petitioner is using endolite, all caps, ENDOLITE, RT dot prosthetic leg. And the seed company has only one branch at Guwahati in the entire Northeast. For the purpose of regular follow-up, for the purpose of maintenance of the said prosthetic leg, maintenance and proper functioning of the prosthetic leg, a regular follow-up is all necessary. In Annexure 10, the Deputy Chief Medical Officer, MSPL, Oil India Limited had also certified that the artificial limb which is used by the petitioner is available only in Endolite India Limited Guwahati in the entire Northeast. And the checkup or maintenance of the same is essential on regular basis. Ms. B. Sharma, the learned counsel appearing on behalf of the respondent submits
His representation is still pending, Lordship.
that the representation of the petitioner is still pending. And the authorities would require 2 weeks' time to render its decision on the same. In that regard, the learned counsel has placed before this court an instruction issued by the Group Commandant CISF Headquarters Guwahati dated 27/5/2023, which is kept on record and marked with the letter X. Taking into account the above, this court therefore stays the order of transfer dated 31/5/2022 insofar as the petitioner is concerned, as well as the office order dated 15/5/2023 issued by the Assistant Commandant CISF insofar as the petitioner is concerned, till the next date.
All right.
64.
Yes, Mr. Vatak.
Lordship, this is a case, your lordship, the case is a transfer you matter, your lordship. The petitioner, your lordship, has 11 months to go for his retirement, your lordship. A transfer order has been issued, your lordship. And in fact,
Transfer, where is the transfer order?
your lordship, that is at page 12, your lordship. From Dhaligaon to Mirat, your lordship.
Transfer of commandant to by the competent authorities is hereby transferred to Rapo Merat with immediate effect due to administrative operations constraints of court. The officer may be relieved to his new place of post.
Now he filed a representation, your lordship, saying
Then-
that since I have 11 months left, I should be allowed to stay here and retire from this place.
My son has got married on 27/2/2000 and my daughter-in-law is taking my care of my aged father, my wife. That less than 1 year is left of my retirement. That's why after completing my 11 months left. Yes, then
And then they rejected this, your lordship, and therefore, your lordship, I am before this honorable court, your lordship.
we in order.
Page 14, your lordship.
Then
Now, your lordship, no, then I am before this honorable court. your
understood, but what is your case?
Now, your lordship, case is, your lordship, is this, your lordship, that if your lordship takes up the standing order, your lordship.
Why have you not enclosed the standing order?
I could have, your
If
lordship.
you are
but
there,
Somehow.
if
your
your
lordship.
trump card is that, why is that not on record?
No, your lordship, I have got it, your lordship.
That's now.
No, not that now, after filing of the case.
So you filed this without knowing this.
Lordship, I am told, your lordship, but the copy they have not provided me.
Yes, you are referring
Your
to
lordship, that's your
Clause
lordship, the
12.
main feature of this policy, your lordship.
Huh?
1, 2, 3, your lordship. The main feature of the policy.
Yeah.
The normal tenure from assistant commandant to DIG would be 3 years, your lordship. Now, your lordship, I have completed 2 years, your lordship, in the present place of posting, your lordship.
You are now made DIG.
No, not DIG, your lordship. Assistant commandant to DIG. From level of assistant commandant to DIG, your lordship, I am commandant, your lordship. So, your lordship, I was transferred, your lordship, before completion of that tenure of 3 years. Now, your lordship, the authority has, your lordship.
Where does it say that you can't be transferred?
No, your lord, not saying that. No. Clause 3, your lordship, normal tenure From assistant commandant to DIG would be 3 years.
Okay.
Now your lordship will kindly see your lordship. This is the normal tenure and I have completed 2 years here, your lordship.
So you want as a assistant commander in that
Assistant
place?
commandant, your lordship. No, as a commandant, your lordship.
You are transferred as commandant.
No, your lordship, I am transferred as commandant, your lordship. I am holding the post of commandant, your lordship. Now, that is not my case. What I am saying, your lordship, before completion of tenure of 3 years, I am being transferred, your lordship.
Where is it mentioned you can't be?
Your lordship, it says a normal tenure from.
So you are still as a normal tenure in the same post, does it say?
No,
same location, does
yes,
it say?
yes. This is the, your
That
lordship.
is why it is not here.
No, your lordship, it is a 3 years, your lordship. Normal posting, your
Is
lordship.
there nothing?
Lordship. And secondly, your lordship will kindly see, your lordship, why I am here, your lordship. I have, in fact, it is not that before 3 years I have not been, your lordship, transferred. Prior to this, your lordship, 1.5 years, 2 years, your lordship, I have been transferred. I have, your lordship, I have accordingly, your lordship, without any demur, your lordship, I have accepted that, your lordship. And in fact, your lordship, in 2021 itself, I have submitted a representation saying that I may be transferred since I have 2 years of service left. Then they did not consider, and even then also, your lordship, I have not shown any demur. Now, your lordship, since only 11 months left of my service, your lordship, last
Mr.
pay end of my
Bhattakur,
career.
I understand everything. Being, I also feel for it. But for that, you have to, for passing an order, you need to show me some.
No, your lordship will kindly see that when they say that the normal tenure for your lordship, normal tenure, your lordship, in a particular place, your lordship, is 3 years, your lordship. Then your lordship, when they say that they are not complying that guideline, your lordship, they can, your lordship, but they will have
Normal
to
tenure in the same post.
No, your lordship, that is the same.
Where is it mentioned that you can't be transferred as a commandant? It was only said normal tenure from assistant commandant
Your
to
lordship
DIG
will
would be.
kindly see, your lordship, this says the transfer policy for the very subject, your lordship.
Understood. So
Transfer
normal
policy,
tenure from assistant commandant to DIG will be 3 years.
3 years, your
So it
lordship.
is from assistant commandant, then there will be commandant, and what else?
Then your lordship, DIG, your lordship,
Then,
I probably.
so
your
these
lordship,
3-4 posts which will be there will be for 3 years.
3 years in
Within
a
these 3
particular
years,
place.
he has to reach there.
In a particular place of posting, your lordship.
Where is it there? That is, should I incorporate it?
Your lordship, they have not, but this is the policy, your lordship, and they can, your lordship, confirm with your lordship. This is the policy and that has been followed, your lordship, on the basis of this, your lordship. And it is not that, your lordship, I say, your lordship, yes, they have the right, your lordship. Being an employer, they can, even after, before completion of 3 years. But the
challenge the policy.
No, your lordship, we should not challenging.
Why they have not included?
But your lordship, this is your lordship that they have been following, your lordship. That normally 3 years, one place of posting, your lordship. Now, your lordship, why I am here, your lordship, since I would not have been here, your lordship. Had your lordship at least 2-3 years have been left. 11 months left, your lordship, I will have to go, then have to settle there, your lordship. Then from pension, etc.
So,
That is
don't
why-
worry, they will give you a pension.
No, pension will be given. The entire thing will
Why,
have
if
to be
you are
processed.
worried that if the pension happens or if you retire from some other place, then the petition for pension has to be moved in some other high court.
That is not the case, your lordship. That is not the case. And your lordship will kindly see, your lordship, when your lordship at the peg end of his career, a person going beyond your lordship, their own transfer policy is your lordship transferred, then at least there will have to be some pressing, your lordship, necessity, your lordship. And when they rejected my petition, your lordship, at least that should have been a speaking order, your lordship. That should have been a speaking order. It says that, your lordship, on administrative exigency, your lordship, he has been.
I can give you at least one. That is the only. You go join there. No stay or nothing to that. And they will pass the. And if they think so, they may take nothing more. And I am not going to say. These are all administrative exits.
No, lordship, I understand that, your lordship. That is why, your
This
lordship.
court is not going to touch all this. You want a representation with reason order, they will pass.
That can. Then at least till that time.
No.
Because your lordship, ultimately, if they don't take,
They
your
will
lordship,
bring you back. They can send you, they can
that
bring you back.
once your lordship, they will send me, your lordship, they will not bring me back. That's what your lordship.
They will in fact
Now your
do
lordship will
it.
kindly say,
If you follow their order, they will do it.
your lordship will.
I will just point out one thing on his representation. If your lordship will see his representation, paragraph 4, he was at first worried about his parents living in Delhi. Now his son is there. Now where is he transferred to? Meerut, 100 kilometers from Delhi. In fact, he should be happy.
No, I would have been happy, your lordship, had
He
they
should have been
considered
happy.
it at the time when I prayed for transfer in the year 2021. I made a prayer, your lordship, that I should be
Maybe some
transferred.
other reason, lordship, he wants to specifically retire from this part of it.
What maybe I myself has prayed for, but they did not, your lordship, allow my petition, your lordship. Therefore, your lordship, I oblige.
Mr. Rochadri giving a credit to this court. For pension, he can move this court.
That is.
That's what your lordship, my prayer is. Your lordship.
Okay, sorry. Heard Mr. S. Bhattakur, the learned counsel, appearing on behalf of the petitioner. Mr. R.K.D. Chaudhary appears on behalf of all the respondents. The instant writ petition has been filed challenging the order of transfer dated 11/5/2023
and subsequent, your lordship, rejection.
and the order dated 18/5/2023 and as well as the order dated 18/5/2023, whereby the representation of the petitioner has been rejected. From a perusal of the materials on record and the submissions made by the learned counsel for the parties, for the petitioner, it appears that the petitioner's case is that he has only 11 months of his career left, and as such, the same order of transfer should not be given effect to. It further appears from the representation so submitted by the petitioner that the petitioner initially, upon being transferred on 4/12/2021, had submitted an application that he may be transferred within the vicinity of Delhi, as his aged father and wife are suffering from back pain. However, the same was not done so, and as such, the petitioner has been posted at
Bongaigaon, your lordship, Dhaligaon.
At Bongaigaon.
Dhaligaon and Bongaigaon.
Dhaligaon. It is the further case of the petitioner that the petitioner has only left 11 months in his career, and as such, he should not be again transferred to Meerut, which have been done so by the impugned order of transfer. This court, taking into account that the services of the petitioner, that the transfer being an incidence of service, and the limited scope of interference in transfer proceedings, is not inclined to interfere with the order dated 11/5/2023 issued by the authorities concerned. Accordingly, the petitioner However, this court observes that the petitioner, after joining his place of posting, would be at liberty to submit representation before the authorities concerned, who may consider the same as per its policies.
If your worship allows me to at least submit before joining your worship, then I
Join.
will go, your worship.
Join, go, and
Then that will, your worship will never get your worship after going. If your worship at least grant me liberty to file it before
Mr.
joining your
Counsel,
worship.
I know why I'm saying that. Asking you to join and then they will listen. There's something which the lawyer also needs, na, as an order to show after an initial dispute.
And number 65 for admission, part hard.
Where is Mr. Gogoi?
I had a price about it yesterday.
Hmm? Who has fallen?
Mr. The neurologist concerned, Dr. Pirkeyal.
You gave the name of some other neurologist.
I had given a name. I had suggested a name. At that point of time, Mr. Gogoi had said that he's a little junior, and so we had all consented to keep Dr. Kayal as the neurologist. Dr. Nabujyoti Borkotik urologist.
You gave the name of?
Dr. Nabujyoti Borkotik. I'm just once again refreshing your lordship's file.
Dr. Nabojyoti Borkotik.
He is also.
Let him, please call him.
And
Yes, once he comes, I'll pass the order in his presence. I have the details of Nabojyoti Borkotik.
Lordship,
But he is willing, na?
yes, he's willing. Just that neurologist part was not written in the earlier communication which I had handed it over to your lordship. I had just written neurologist there, the new one which Mr. Singh is holding.
I could see it here. It is there.
The rest, all his particulars are all there, your lordship. His registration number, his address, and everything, his contact number.
It is there. Let me see. Yes. Dr. Nabojyoti Borkotik, registration number 11184, address ARK Neuro Center,
Yes, your lordship.
contact
Everything
number
is
9.
same, just that I had forgotten to write neurologist in the brackets. That is all.
It is, oh, neurologist.
I haven't written that.
So please call him out at 2.
At 2. Lordship, I have maybe accommodated.
You are there for help?
No, he is coming, my lord. I have sent him a message, my lord. He is coming right now.
Lordship, at 2, I'm in the midst of a partnered matter with the Honorable Chief Justice. Could I be accommodated for a little?
Okay. Yes, Mr. Gogoi. This court on the last occasion directed on 11/4 for purpose of what you call report on 15/6. Now, till now, the commission did not sit because of the fact that Dr. Kayal is not well. So she says that the other person be appointed. He has no problem, Dr. Nabojyoti Borkotik.
I have no issue.
Heard Miss R. Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. B. Gogoi appears on behalf of the Health and Family Welfare Department. This court, by the detailed order dated 11/4/2023, appointed a commission consisting of Dr. Ashok Kayal and Dr. Rashna Das Hazarika to give a fact finding in terms with the terms of reference as set out in paragraph number 13 of the said order. This court, by the said order dated 11/4/2023, had also directed that the report be submitted by 15/6/2023. Mrs. R.S. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that the commission have till date not set, taking into account of the ailment of Dr. Ashok Kail, taking into account that this is an old pending matter, this court, in the interest of justice, reconstitutes the commission to consist of Dr. Nobojyoti Bokotoki, who is also a well-renowned neurologist, and is engaged in ARK Neuro Care Center, along with Dr. Rashna Das Hazorika, who was earlier appointed by this court. According Accordingly, this court further directs the commission, the registry, to serve a copy of this order along with the order dated 11/4/2023 to Dr. Nobojyoti Bokotoki as well as Dr. Rashna Das Hazorika, the members of the commission so reconstituted herein, forthwith. The members of the commission thereupon shall submit the report within a period of 2 months from today. That is on Adikidai 29. We'll have it on. Shall submit the report by we're going to August 9.
First of August is a Tuesday.
By 1st of August 2000, no, we can't put it on first. You can put calendar. तो कैलेंडर ना इकोन उठाओ, ऊपर उठाओ, जनवरी आ गया, उसके बाद क्या होगा, जून की बात, जुलाई दिखाओ, अगस्त. We'll have it on 8th of August.
Well,
Fixes this matter to submit the report on or before 8th of August 2023. The rest of the order, the rest of the directions so passed in the order dated 11/4/2023. And the instant order shall be a part of the order dated 11/4/2023.
Perhaps pray that the registry may be given a direction to comply with this order within a time frame, because from the registry to the notice to go to these people has taken a lot of time, Your Lordship. So that perhaps
This court further forfeit to this court forfeit to bold letters, and not later than 7 days.
here is one communication of Dr. KL, let it be kept in record, man.
তাতে উপৰত লিখি দিব লাগিব, what? has not been well believed to the collect. Mr. B. Gogoi has also placed on record a communication issued by Dr. Ashok Kyle expressing his inability to take up the matter, taking into account of his ailment. Look, the same is kept on record and marked with the letter. এখন ভৰাই দিওঁ।
Hello, 13.
For last order, Lordship, they may take. Lordship, I have received the instructions. Order 94. VRS scheme of the for employees, your Lordship. Now. Lordship, total amount was around 30 crores. Now, out of which 12 crores has already been released and it has been credited into the accounts of the petitioner. Yes, sir. A remaining amount of rupees 18 crores, for that we need to send a supplementary budget. But before that, we need to submit the utilization certificate in respect of the 12 crores amount. Now, that has been some certain mismatch has been done by the chartered accountant fund. So we have communicated to the chartered accountant to clarify on that, and once we get the clarification, we'll place the utilization certificate before the concerned department, government, and subsequently we'll process with the supplementary budget of the remaining amount. Lordship, may I pray that let the matter be fixed after the summer vacation? So it will take some time, Your Lordship.
Mr. M.D. Bora appears on behalf of the respondent number 4. The learned counsel for the corporation department submitted that initially the total VRS claim of Apple was found to be 33.22 crores, on the basis of which 12 crores have already been released and the said amount have already been disbursed to the petitioner. However, upon further verification, it was found that the total amount was not 33.22 crores, but ought to have been 30.60 crores. Accordingly, the corporation department is taking appropriate steps in that regard so that a further request for the supplementary budget for disbursing the said amount to the petitioners can be done. The learned counsel appearing on behalf of the corporation department submits that the respondent department be accommodated by a period of 2 months so that appropriate steps can be taken in that regard. Accordingly, let the matter be listed again on August. August no, June nahi. July ko logai diyo na. July ko log. July ko log option. July thekile August thekibo tu. Be listed again on 8th of August to 7th of August 2023. The Learned Counsel for the Corporation Department shall apprise this court on the next day as regards the present state and as regards the status of disbursal of the amount to which the petitioners are entitled. The communication issued by the Eastern Register of Cooperative Society, so given to the petitioner, so issued to the counsel for the respondent, is kept on record and marked with the letter X. Yeah.
Board action list item number 1 for motion.
Please, your thoughts.
Yes.
Lordship, petitioner is presently serving as a constable in CSF unit OPS on your Lordship. Is agreed by the impute transfer order service number 6/23 dated 3/5/23. Your Lordship will find at annexure B page 19.
Petitioner name Montu Boro.
Montu Boro.
Transferred from where? Where is he?
From OPS Nunmati, your Lordship.
Serial number?
Impute order at annexure B page 19.
Serial number?
Serial number, Lordship will find at 199, 21 page number.
From Nunmati
yes.
to Duliagar. Yes. What is your problem?
The problem, Lordship, first problem is that his mother is completely dependent on him. His mother suffered from brain hemorrhage, and that treatment is going on, and he's fully dependent upon the petition. That is the first problem. May I take your Lordship to page 31?
Page
31. One of the relevant medical documents of his mother. Lordship will find final diagnosis. Right thalamic lead with interventricular extension. And the last part, on the last line of this page report, CT brain reveals fissure suggestive of acute hematoma in right thalamus with Lordship interventricular hemorrhage. So that was a brain hemorrhage. So first she suffered Lordship, and she was treated in the Hyatt Hospital, and thereafter although she was released, but she is not getting recovered fully, your Lordship.
Then?
And at present she is undergoing treatment in the Rahman Hospital.
Huh?
Rahman Hospital, Guwahati, your Lordship. That's page 24. She is undergoing the treatment, and she completely depends on upon the petitioner, because he is the only son and she is fully dependent on him. So that is a first problem, first medical ground, your lordship, so far. And his CISF unit, OPS non-marty is the nearest.
What does your father do?
Father expired, your lordship. His father expired, so mother is completely dependent on him, lordship.
So is it not possible
Lordship,
that Duliajan also provides similar
and
thing?
another problem is that, my lord, his wife, since she 3 months old pregnant, your lords, it's a crucial time.
What?
3 months old, 3 months pregnant, your lordship. It is a crucial time as per instruction of the doctor. She should be refrained from this traveling and all this.
Where?
Hard works. Your lordship will find at page 39. And anomaly tests scans are also going on here under the concerned doctor. The last line suggested follow-up for first trimester anomaly scan, 11 to 13 plus weeks, your lordship. That scan is going on, anomaly scan. So that is because she is undergoing the treatment of the concerned doctor, gynecologist. So that is why.
There is no doctor out there in Duliajan?
No, that is there, but she is completely under the supervision and guidance of this doctor. So that would be difficult for her.
Why?
Because the gynecologist is here in the Pratiksha hospital, and under whom she is undergoing that, she is undergoing the constant supervision. And time to time, here, this anomaly scans and everything. That
What
is one
scan?
aspect.
This is normally every 3 months, every 2 months, these scans are going on. So how does it matter?
So, lordship, here, this is the two grounds so far I have submitted before your lordship. Basically, his mother being a dependent, helpless woman, he cannot leave his mother at this stage.
No, why can't she go there?
No,
Duliajan?
because here under this concerned doctor, her treatment is going on. And so far, your lordship, the Guwahati, this medical facilities.
Duliajan, there is no medical facility.
There, but not up to that mark, your lordship. And because he has to bring his mother to Guwahati on. So in terms of the journey and taking her quite often to Guwahati is also, it will be troublesome for him. I see it will face difficulty a lot. And he cannot leave his the pregnant wife also. Lordship, so far, may I take your lordship to page 19 again, and actually be here at D. Your lordship will find at D. Page 19, your lordship. Lordship, here at D, it is articulated the representation of the individuals, if any, will be forwarded to his this headquarter directly by concerned unit commanders with justification recommendation in consolidated manner on or before 12/5/2013. According to your lordship, as part of instruction, your lordship.
You have submitted a representation of 3/5.
Yes, lordship will find at least 40. Annexary.
Now what has happened?
That is not even recommended, your lordship. That has not been also followed. Here it is not recommended by the commandant, that is not even forwarded to the competent authority also for consideration.
How did you submit your representation?
I submitted representation for proper channel. That is through the assistant commandant of the CISF unit of PSN material laws.
No, the representation has to be sent by duly scanned PDF mode to the headquarters.
That is done by them.
No. Of the individuals, if any, be forwarded duly scanned demand in this to this headquarters directly.
Directly by concerned
by the
commanders.
concerned unit commander with justification recommendation in consolidated manner on or before.
By unit commanders.
Then
this is the way the representation is submitted.
Where's the central government council? Get hold of them.
That is not even recommended. That is not even recommended and forwarded. So from my grounds are there.
This will affect from, you are in the second phase.
Yeah, I'm in the second phase. It will affect from 31st. On 31st, I will be relieved, Lord.
You will be relieved. But have you sent it in the, have you given it? And has it been sent by, yeah, you are not aware of
It is reflected here also. I have collected one here. So here it is not recommended, it's written. May I submit it to your lords? I have collected because they received the representation by the commandant, but he has not recommended it. I have not forwarded to the competent authority. Somehow I collected it. Want to call? That is a remark of Group Commandant Guwahati. That has not even forwarded. That has not been forwarded.
No, he is not, he's saying that without recommendation. But is he saying that he is not forwarded?
As per D, as per clause D, that ought to have been forwarded to the.
No. Are you saying that it has not been forwarded? You see, what is required is concerned unit commander with justifications of the recommendations in the consolidated manner on or before 12/5.
Yes,
That is being asked for. He has not recommended your case. That's a different aspect to the matter.
Yes, my lord.
But he has not forwarded. How do you say?
If had it been forwarded, lordship, that would it would have been recommended.
No.
It would have been.
He has to recommend.
He has to recommend, and after his recommendation, it will go to the proper authority.
Headquarters.
That is the headquarters.
But this is not recommended means this has been, he has not recommended it, but he has forwarded it. There's a difference to them because he has to give his justification if he wants that the transfer should not be given and recommendations on no.
So for my instruction.
We'll take it up with when the other get hold of the central government council.
Recommendation, my lord, that cannot be placed before that competent order. Without his recommendation, that would not go to that station, your lord, to the competent order.
Where is it meant?
First, no. So for I have got the instruction.
No. Don't give those instructions to the effect. Get hold of the central government council. We'll have a. Central government get hold of the central government council. Whoever. Ask Mr. R.K. Chaudhary. You wait. Once I see a central government council, I'll get hold.
Yes.
Yeah. Next minute.
Same.
15.
Lordship, here in this matter, Lordship.
Oh, this matter. You have paid the money
for leave encashment has already been sanction issued, Lordship. And Lordship, regarding the
what?
Regarding the sanction for arrears, Lordship, that is 1,83,564, Lordship. It is under process, Lordship. It has been moved for concurrence to the finance department, Lordship, because finance concurrence will be required.
But last time I have asked you only on that. Let the matter be taken up again on 29, on which date the Standing Council for the Health Department shall apprise this court as to what is the present status of the payment as regards the leave encashment and the amount of rupees 1,83,564.
Lordship, leave encashment has been sanctioned, Lordship. for 300 days, Lordship.
That has been done.
And Lordship, for this Lordship, we require the finance department concurrence.
The finance is there.
Yes, Lordship.
Whom should we impose the interest? Finance or you?
It will take some time, Lordship, but the things are moving, Lordship.
It says that proposal for sanction pertinent to it is source to perhaps it has not been transmitted to the finance department as on today.
Otherwise, Lordship.
Have you sent it to the finance department?
Perhaps not, because
then we impose interest.
Lordship, otherwise, Lordship, the things are moving, Lordship.
No, I'll direct this. I'll dispose of this matter with the direction to pay the said amount of 1,83,000 plus 18% interest, which shall be borne by the who is there? Secretary to the Government of Health and Family. Principal Secretary. He has to be a secretary. From his salary, it will be deducted, whatever. From when you are entitled to?
Lordship, proposal was sent only on 27/4/2023 by the Directorate, Lordship.
Understood, but he was entitled to when this amount? This amount of area salary, his entitlement is from when?
Area revised pay, Lordship, from 1996 to 1998.
Area DA?
Area revised pay, my petition.
Oh, this one, 1/1/1996 to 31/7/1998. That comes to 1,83,000.
Yes, Lord.
Then these affidavits have been filed long time back,
Yes,
admitting that amount.
yes, but
Then it's no sense out here to keep the matter pending. And for you, the matter keeps on coming. Judicial time is lost. You filed the affidavit on 26/5/2022 stating that his entitlement of leave encashment.
Yeah.
Now, till now, you have paid now? Have you got the leave encashment? 300 days.
Lordship, it will be issued by the AG, Lordship.
AG is where? Yes. Have you got any information on this?
No, my lord, we have not received the proposal.
Then this is only just for the. These are letters only issued to you.
Yes, Lordship, but it's
Then there's no value. This has not gone to the department.
Letter is, my lord, today is 29th of May. My
You do it only on the day on which the matter is there.
No, not previous.
No. There's no on this
Lordship, on
aspect.
26th also, Lordship. Proposal was sent on 27/4/2023, Lordship, by the Directorate. Lordship, I have the proposal.
Have you sent the proposal to the finance department till now?
Lordship, regarding the area, Lordship, to my instruction, maybe not, Lordship.
Then what are you doing? Heard Mr. A. Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. D. Upamanyu, the learned counsel, appearing on behalf of the Health and Family Welfare Department. Mr. R. Babudari appears for the Finance Department. And Mr. You are there?
Yes.
And Mr. A. Hassan appears for the Accountant General AE. Today, Mr. Edipu Upamanyu has placed on record particular instructions to receive from the Secretary to the Government of Assam Health and Family Welfare Department, dated 29/5/2023, wherein it has been mentioned that the sanction for leave encashment for 300 days have already been issued by number HLA 209820/20 dated 26/5/2023 to the AG Assam for issue of payment authority by the AG Assam in respect of joint DHS Jorhat to draw and disburse the amount. The learned counsel appearing on behalf of the Accountant General AE submits that as per his instructions, nothing of such have been received by the office
Lordship,
of the
it has been
Accountant
sent
General.
to the transfer here. Lordship, I have a copy.
Hmm?
It has been sent, Lordship, on 26 May, Lordship. I have the letter of
Letter
26.
dated 26, my lord. The letter dated 26, my lord, but we have not received it.
Copy was
The learned counsel, Mr. D. Upamanyu, submits that the same was sent on 26/5/2023, and as such, it may take some time to reach the office of the Accountant General. SAM. As regards the area's revised salary for the period from 1/1/1996 to 31/7/1998, it has been mentioned in the communication dated 29/5/2023 that the proposal for sanction of rupees 1,83,564 is under process. It was also mentioned that as it is an area salary, so the concurrence to the finance department is required. This court made a specific query upon the learned counsel appearing on behalf of the Director of Health and Family, on behalf of the Health and Family Welfare Department, as to whether, as per his instructions, the proposal has been submitted to the Finance Department. The learned counsel, with all fairness, submitted that as per his instruction, no proposal as such have been submitted to the Finance Department yet. Taking into account the above, this court fixes this matter again on 21st of June 2023. This court puts to notice that Secretary to the Government of Assam the Secretary to the Government of Assam Health and Family Welfare Department as to why interest at the rate of 12% should not be imposed on the delayed payment of the leave encashment, as well as the sanction, as well as the amount of rupees 1,83,564 from the date it was due. And the said interest be recovered by the authorities concerned from the salary of the Secretary to the Government of Assam Health and Family Welfare Department. In that regard, the liberty is given to the Secretary to the Government of Assam Health and Family Welfare Department to submit an affidavit justifying why the interest as proposed should not be imposed upon her. The instructions so submitted by the learned counsel appearing on behalf of the Petition Health and Family Welfare Department is kept on record and marked with the letter X, Y. Letter Y.
highly obliged.
33.
Obliged, good.
Mr. Rashid, on that day, that matter, eviction, you remember? I've asked the Deputy Commissioner to give it back to you, the land.
Yes.
Yes, remember? You said to me that the matter was pending before the civil judge, which is not so. The appeal was filed before the deputy, before the district judge.
Decisions not go. Decisions not go.
Thereafter, on 4/3/2021, the district judge transferred the matter to the district judge Hosai. The district judge Hosai thereupon have re-registered it as title appeal number 14/2021. And thereafter the matter appeal is pending. You had also no idea about the title suit number 77/2011?
So there are two credit with me.
Understood.
One from our side, one from their side.
Yes, but then also you are supposed to inform this court. Is it the duty of this court? Have you got that order or not?
I have not applied it.
Why? Not necessary.
Necessary, my lord, but
Then-
he is to come, my lord, but he is not come here.
He has not come, it's a different thing. Isn't it the case out here for you to take it out and so that there is a direction given?
I haven't.
Then why haven't you withdrawn? Why do you not withdraw the
I
petition?
haven't informed him. Our phone.
Then whether he comes or not, isn't it your duty as a lawyer to inform him?
No, I haven't.
Then what is the order being passed?
I have confirmed this is the order.
Then?
He is to come, but he has not come.
Then why should this court pass any order in your favor out here? If the person would not come, you would not inform your client about this.
I have informed him.
Then-
Our phone I have informed, but he has not come here, so I could not obtain that.
The Justice app we have nowadays, the Justice app. It helped me to find out and trace out what happened to the DP. Email. You remember that case?
Yes, because Lordship has directed for restoration.
Absolutely.
On the count that Deputy Commissioner
Had no authority to do
No,
that
he
when
has-
there is a matter
he
pending.
has assumed the jurisdiction of a civil court.
Huh.
That's it.
That is what. Now he said that it was pending in the civil court, the civil judge. Now if I had put it out there, luckily I didn't do it. I didn't trust him, and good for that. And then when I looked into the map papers out there, saw it out there, it was never before the civil judge now. It was filed before the district judge, and after that it was never sent to the civil judge. It went to the on 4/3/2011. Taking into account the 21, taking into account the Hosai, having been formed in view of the particular notification issued by the High Court, all these matters were transferred to District Judge Hosai. Then I inquired out there from the District Judge Hosai and found out that the appeal has been differently numbered. It is 14/2021, and it is at the stage where it is pending at the stage of what do you call substitution. The petitioner counsel is not aware.
I am not aware of this.
Then
Sorry, Lord, I am not aware of
no,
this.
you should not make, because unless you are not aware, because if I had put it out there, where will these people search for the civil judge Nogau's matter? The appeal was not there.
And transfer portion were also sorry. But the-
And your people were appearing out there. You were the appellant out there.
No,
You,
I was not.
yes, you were the appellant in this title appeal 30 of 2016. You were the appellant. Then,
Yes.
and when you filed the writ petition, you filed the writ petition in 2021.
21.
And you should have known that aspect of the matter, if it not, because 2021 that order was passed. And at that time it was pending in Hosai.
Sorry, I am all this not. Sorry.
Now, I have passed an order directing the deputy commissioner to vacate, hand over the possession.
Yes, sir.
And he has not taken even the certificate copy. They are not interested.
I have not searched last week, but it was not found in the net. So I did not apply. And party is to come, but not come yet. I have informed our phone, but not yet. And if I obtain like keep in my hand, how can it is to be taken by
Maybe perhaps because of the reason that they are out of position, my lord, maybe I do not know. Because in the civil suit, my lord, in the trial court decision, there is a clear finding that they are out of possession, rather than other side, other party, their adversary, they are in possession. So my lord has directed, because my lord has interfered with the order passed by the Assam Board of Revenue.
No, no.
Now nobody.
See, the most interesting thing is, to the affidavit, there was a instruction enclosed.
Yes, I have also, my lord, inquired into that. I couldn't find that instruction.
That instruction clearly says, which have not been mentioned out there in the affidavit, that the deputy commissioner took over the possession from them. And on the ground, there was nothing in there. And he says he has the audacity to say in his instruction to the council, and the council puts it on record by way of an affidavit, that this was a land belonging to somebody and he was illegally possessing. And as such, I have the power under 165, so I am exercising. I have recorded, I have put it inside.
Yes, Lordship has recorded it.
No. I have put that portion of the instruction. Like in the other case also. That was, which I think you have got the copy?
Yes.
Whereby there is a direction to take over. You must have got that copy.
No. That copy I haven't, my lord, received. As of now. That is, my lord, yes, Tinsukia matter.
No, not the Tinsukia matter. It was nearby here somewhere. Nalbari, somewhere other than that his matter was the first matter, the second item, where I had it said that you go there and that 3.1 of the policy, land policy.
Yes, that is the
You have
matter.
not got the copy?
No, my lord. That is perhaps, my lord, pertaining to Tinsukia district. I may be mistaken, but because they were occupying almost 3 bighas of land. Chief has come to a finding that under the land policy.
No, not 3 bighas. 1 bigha, 1 katha, 6 less.
Yes,
And his entitlement was 2 katha, 10 lessers.
2 katha 10 lessers as per the, my lord, 3.3, I think, of the land policy,
yes.
2019.
Yeah.
Yes. So Lordship has directed the authorities, revenue authorities, do not disturb him for 2 katha 10.
No, I have asked the revenue authority to demarcate the land,
Yes, demarcate.
take the best portion
Yes.
which is required, because in the instruction it has been mentioned that they want to establish a particular office out there.
Yes.
And because he is occupying the front portion, that is the difficulty which is faced.
Yes. And tomorrow his settlement proposal will be considered. If it is found that he is not entitled, then he will have to vacate.
You have the number of the
My
case?
lord, I will have to charge, my lord.
At a more direction this to give a copy to him. Why no copy has been given to him till now? It's on the same date, now both the orders were passed.
Yes, my lord, the council, Mr. Udas appeared. I remember.
Yes.
Udas appeared.
I think this was on Monday or
22.
Monday, na?
22.
22, na? 22 तारीख को सब.
Monday.
22 तारीख को list को. Take out a copy and give it to him. Make it true copy and give it to him. He will take it up with this. Because otherwise, if it is not given, as I could learn today in another matter, there is a direction to the registry to forthwith send a report, the commission report to the order to the commissioner, and it has not been done till recent. That matter where Mr. B. Gogoi was a case. To order to life.
Yeah, I will take it up, my lord.
He will give you a true
Yes,
copy.
yes.
Yes, Mr. Husi, tell me.
In this case, for area salary, my lord.
Have you got it? Got the money?
No, my lord, on the last occasion, my lord was pleased to implement the treasury officer and accountant general. I have taken up the matter with treasury officer Hosai. My lord, he is on sick leave, but I have already had a talk with his subordinates. They say, my lord, they perhaps have not received any mandate, my lord, from the accountant general, because it will have to come from the accountant general. Because Lordship has passed that order on the strength of an instruction.
Issue the communication to the accountant general, thereby conveying the sanction of the governor for the payment of so-and-so as area salary in respect of the petitioner from so-and-so. The state sanction order has been placed before it and kept as wire. However, it is seen that accountant general as well as is not a part. Yes, accountant general. Have you got that order?
I have that instruction, my lord, that was placed on the last
Lordship,
occasion.
as per instructions that I've received from the office, we do not have any role regarding arrear pay or pensionary benefits of provincialized schools.
But why it was then issued to the these people? Why this was issued by the undersecretary to the government to the accountant general?
This is the procedure we adopted, my lord.
Huh?
This is the procedure we have for sanction. We have after sanction we have sent to the accountant general, my lord. This is the
Yes,
procedure.
but why it has been sent to the accountant general? You should have sent it then if they don't have any role.
Accountant general perhaps will be required because of the fact, my lord, that
They say the accountant general is a party of the accountant general said we have no role in this.
I may furnish the.
That on account of the interdepartmental thing, this has happened. তার আগৰ অৰ্ডাৰটো ওলাই দিব সিদিনা আগৰ অৰ্ডাৰ এইটোতো আছে চাওঁ এইটো আৰু ইয়াৰ
now, my lord, if the accountant general says, my lord, they do not have any role, then perhaps, my lord, direction have to be issued to the DDO, Drawing and Disbursing Officer.
Who is that?
Because the treasury officer, my lord, he acts on the mandate.
DDO will be them only.
Yes, my lord.
Then-
Did you, my lord?
No,
Normally the
why is this
headmaster of the school, my
confusion?
lord.
You have settled it, he is entitled to, there is nothing out there, then why he is not getting the money?
But normally, my lord, as per my knowledge goes, my lord, always you issued to the accountant general. my lord.
Yes. therefore,
Then why the accountant general is shying away from the responsibility? $135 कोई तक दी I do one thing. I dispose it of within 4 weeks.
Yes, ma'am.
You should get the money.
Yes, yes, because since it has been sanctioned.
Else, it will incur interest at the rate of 15% to be taken from the airing of ships. It is your responsibility.
Yes, my lord.
But making this order would not make any sense. You would not take out the certified copy.
I'll today itself I'll try. Today itself and I'll try to copy. Today itself.
Lordship may keep it pending.
No, not pending. Why should I keep it pending? Everything is being done. Why should I keep it pending? You pay the money within, today is what date? 3/5. No, today is 29. By 29th of June, 29th of June, it's Thursday. You have to pay the money. If you don't, interest at the rate of 15% shall be paid by the authorities who are responsible. That you find out amongst yourselves. Or I put it like this, from the date they submit the certificate. Then you get another 2-3 months.
Since it is sanctioned, it will be paid. There is no difficulty.
No, understood.
But
You
I
will
am
get
on the
another 2-3 months.
Procedure, my lord.
Heard, Mr. A received the learned counsel for the petitioner, Mr. N.J. Katania, appears on behalf of the Department of School Education. Mr. S.R. Borua appears on behalf of the Director of Pension. Mr. R. Bopujari appears on behalf of the Treasury Officer Hojai. And Ms.
P. Swargyari.
P. Swargyari
Swargyari.
appears on behalf of the Accountant General AE. It appears from the records that on 3/5/2023, this court had duly taken note of that the Department of School Education had already issued a communication to the Accountant General AE conveying the sanction of the Governor of Assam for payment of an amount of rupees 3,09,069, which is the area salary of the petitioner. from 1/1/1989 to 37/2017 during the financial year 2023-24, subject to various conditions. The said communication have already been kept on record and marked with the letter Y. This court had also, by the same order dated 3/5/2023, implemented the Office of the Accountant General as well as the Treasury Officer Hosai. Today, the learned counsel appearing on behalf of the Accountant General submitted that the Office of the Principal Accountant General AE has no role to play with regard to the authorization either of the area pay and allowances or of the pensionary benefits to provincialized school teachers, as the said matter purely falls under the jurisdiction of the concerned department of the government of Assam. It was further mentioned that the only rider is the payment of the accumulated GPF amount, which the said Office of the Accountant General have already finalized and settled the GPF final payment as regards the petitioner, in accordance with the General Provident Fund bracket Assam Service Rules 1937, amounting to rupees 3,84,804 by an office authority dated 26/2/2020. The said instruction, so submitted by Ms. So-and-so, the learned counsel appearing on behalf of the Accountant General, is kept on record and marked with the letter Z. Mr. R. Babujari, the learned counsel appearing on behalf of the Treasury Officer Hojai, submitted that he has that the Office of the Treasury Officer Hojai have till date not received any communication for the really disbursing the said amount of rupees 3,09,069. Taking into account the above, that the amount has already been sanctioned, as mentioned in the communication dated 2/5/2023, issued by the Undersecretary to the Government of Assam, Department of School Education. The respondents, that is the respondents, that is the Department of School Education, as well as the Treasury Officer Hojai, are directed to disburse the said amount of rupees 3,09,069 within a period of 1 month from the date a certified copy of the instant order is served upon the respondent number 1 as well as the respondent number 7. With the above directions, the instant petition stands disposed.
My lord.
Yes, this order I have given it to you, Mr.
Yes,
Babujari.
yes, I have.
Have a look.
My lord, I stand corrected. It is, my lord, with regard to Kamalpur revenue cycle.
I told you
Yes,
somewhere nearby.
Yes.
Because this is if you see the instructions I put it, paragraph 1, if you see the instructions I put it,
yes,
it categorically mentions that they wanted to build something.
Yes, fire and emergency service station.
Absolutely.
Yes.
Therefore, at paragraph number 11, if you see my order,
Yes, my lord. 2 kotha 10 lakhs of land.
not only to demarcate and also that he has no right to choose except a compact plot of.
Compact lot. I'm so obliged, my lord.
Order of sound causes item number 1.
Good boy. Yes, Mr. Goswami. What do you have to say on the transfer? Have you read the brief?
My lord.
Now, during the course of the hearing, he has placed a particular document. Now, if you see the order of transfer, which he has mentioned, I think at Annexure B,
My lord.
there is a mention that if a representation is being submitted, the same be sent by way of a PDF in PDF mode to the headquarters, and with the unit commander's justification and recommendation. So what is required to be done as per that particular order is, once a representation is being given, the commandant out here, before whom it is being given, he has no doubt he has to forward it. There is no discretion left on him not to forward. But what he needs to, he may give a justification saying that yes, it may be stayed or not given effect to, or he may give his recommendation yes or no. Now he submits out here that if it is not recommended by him, by the unit commander, it is not placed before the authority concerned. Because he submits this particular document. Yes, Mr. Bora. You, Mr. Bora?
Yes.
Kindly give him that copy. You have a copy of it?
Yes.
Yes, show it to him. He says that not recommended when it has been given by the group commandant.
No.
He does not send the papers. Is it true? Because as per that particular clause, Annexure B, there is no discretion not to send. He has to send, but he has to give
Yes, so make that justification. With justification is required to forward it. The PDF.
He has to forward. But subject to, but he can very well give a justification. Yes, transfer should be given, or recommendation, yes or no. Whatever. Here it appears from that particular document that the cases of the petitioners are not recommended as per the group command. But was it forwarded?
This document just now I got. There is no signature over here.
The signature
Just,
over here, but
against serial number 17, the name of the petitioner is there. It is in the remark column. It is not recommended. Whether this document is genuine, I have no idea about.
Understood. And as such, the question therefore before this court, or I am putting it to you, is to find out as to whether that particular document has been forwarded.
Definitely.
That's it. I'm taking up tomorrow. You get just that instruction. Because merely, yes, it may be. He may not recommend us. But whether it has been forwarded, because there is no option left with that authority not to forward. If it has not been forwarded, then we have to state. But if it has been forwarded, then it's a different aspect. Okay? Get your instructions tomorrow.
Can it be day after tomorrow?
No, 31st is the last.
Yes.
The request of the Learned Council appearing on behalf of heard Mr. D. Bora, the Learned Council appearing on behalf of the petitioner. Mr. U.K. Goswami appears on behalf of the central government. As the matter has been taken as unlisted, the Learned Council appearing on behalf of the accountant central government submits that the matter be taken up tomorrow so that he can go through the matter. Accordingly, list the matter tomorrow, all the three.
Lordship, so for item number 3 is also similar.
I know that all three are same.
All three.
Not recommended, all three.
No, this is something different.
What is there?
Two is different. 2 is also that representation is pending.
2 I've seen it. It is
So
not
far,
recommended given.
Yes, Lordship.
This Sankorlal Bora is there in number 3.
3, yes.
He is not recommended. He also comes within the same types.
Yes. 1 and 3.
Yes. What about the other one? The
one,
number 2?
Number 2, Lordship.
Jaborani Mondal.
Office memorandum is there.
For what?
This is for the posting of couples, your Lordship.
Huh?
Posting of spouses. Posting of spouses. Lordship, this is the office memorandum or close.
Anyway, we'll take his instruction on
Yes,
that.
yes.
Mr. Goswami,
Malo.
just take it. Because the last date is tomorrow. Day after.
Definitely. I love it.
My
36.
Lordship, standing counsel N.K. Devnar will appear this matter, but he has some personal difficulties with it. He informed me that he filed the affidavit on 16/5/2023.
for this matter, where's the finance? Yes, Mr. Borpuzari. Here, this court specifically asks you a specific query.
Yes, my lord.
Can, in view of the directions given by the division bench in India, can you say that he has been given at a later point of time by the department? You are not going to do that.
No, my lord, only qualification will be 10 years. I have to fairly admit, but
So
lordship,
we allow this because NRD is in support of him, as usual. And the finance is the obstacle, as usual.
my lord, this matter is specifically being my lord, handled by P. Nayak, my colleague. He was supposed to come to the court.
But all along, Mr. B. Gogoi was appearing.
He was appearing.
So P. Nayak was never in the scene.
The last order, my lord.
No, it's a B. Gogoi. Last order also B. Gogoi. The earlier, on 10-4, Mr. P. Nayak was there, but earlier, Mr. B. Gogoi was there. And on the first stage, it was you.
My lord, my lord, give me at least 10 minutes of time after some time. Let me have a talk with P. Govind. Perhaps he might have received some instruction. But I do not find it on my brief, my lord.
Okay, we'll have it after some time. Mr. A. Solia was there. So all finance councils.
No, my lord, I will hear otherwise lordship will dispose, my lord.
No, in this matter,
I
all
cannot go.
finance councils are there. We have 4 councils: P. Nayak, R. Borpuzari, B. Gogoi, as well as A. Solia. All 4 are here on 4 days. Take it above.
My lord, just 10 minutes, my lord. I'm so grateful, my lord.
41.
Yes, Mr.
Yeah, my lord, on 1st of March, on my lord, 21st of March, my lord, your lordship directed them to get instructions, my lord, why my arrear was not paid, and if I'm entitled, my lord, by what time it would be paid.
Yes, what instructions you have?
Yes, well, I have the instruction I have got is the old one, my lord. I have not get the latest one, my lord. I'm praying for some accommodation, my lord, in this matter today.
But Mr. Katunia, the problem arises is on 1/3/2023, 23/4/2023,
And again,
the
12.
same mistake is being repeated by you.
Yes, my lord. I have seen the last order.
So which is the department concerned? Who is to be?
Elementary education.
Huh?
Elementary education.
Elementary. Who is the erring official?
Well, here the director, my lord. Because the
Director
proposal
of
was sent in
elementary.
2017, my lord.
Huh?
But there's one document, my lord. Roshmi, can you come to annexure, my lord? Annexure D, page 15, man. Way back in 2017, the proposal was sent by the district officer, my lord. DEO.
On 12 April, my lord, director has written to the district elementary officer to submit a first proposal, my lord. On 12th April 2023. Thereafter, I have not received any instruction, my lord.
I have taken on 24/3/2023, where Mr. P.N. Sharma, appearing on behalf, submits that the Director of Elementary has taken up the issue as regards the area salary of the petitioner for the period and have directed the DREO to submit a fresh proposal.
Yes, my lord. That I have
Taking
seen.
into account, let the matter be listed after 1 month, 2 months, on which date this court, the Learning Council apprise the Elementary Education Department for a month shall apprise the court as to whether the area salary has been paid. Thereafter, again on 12/5, when the matter came, the instructions for in the orders dated so and so is still awaited from Iman. It is noted that this court on the last occasion had put the AR to notice as to why interest should not be imposed upon the erring officials for the delay in payment of the area salary of the petitioner. This court again fixes the matter on Iman, on which date the learned council shall obtain instruction. Then why nothing is given?
I'm praying for a few days accommodation, my lord. I'll try my best to get it, my lord.
Well, heard Mr. M.R. Adhikari, the Learned Counsel for the petitioner. Mr. N.J. Khatania appears on behalf of the Elementary Education Office Department. It appears on record that this court on various occasions have directed the respondent in the Elementary Education Department to obtain instruction as to why the area salary of the petitioner of an amount of ₹7,36,702 have not been paid. On earlier occasions, it had been brought to the attention of this court that the Director of Elementary Education have taken in the matter up with the District Elementary Officer, Education Officer. On that ground, accommodations were sought for, and as such, this court had fixed the matter on 29/5/2023. However, today also, there is no instructions available, with the council appearing on behalf of the Elementary Education Department. Accordingly, this court therefore fixes the matter on 12th of June 2023. It is made clear that if no instructions are obtained by if the respondent if the council for the Elementary Education Department has no instructions, the Learned Counsel for the Elementary Education Department shall apprise the Director of Elementary Education to be present in the court at 10:30. Heard Mrs. K. Devi, the Learned Counsel appearing on behalf of the petitioner. Mr. N.J. Khatania appears on behalf of the respondent number 1, 2, and 3. In pursuant to the directions issued by this court on 1/11/2023, the Learned Counsel appearing on behalf of the respondent numbers 1, 2, and 3 have submitted that as per his instructions, the provincialization of the school of the petition was wrongly done, as it couldn't have, as it violates the provisions of section 315 Roman 5 of the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017. And it is under such circumstances, the question of releasing the salary of the petitioner does not arise. Taking into account the specific stand taken by the respondent numbers 1, 2, and 3, this court deems it proper that the said stand be brought on record by way of an affidavit, so that the petitioners are in a position to rebut to such allegations. Accordingly, let this matter be listed again on when?
Well, I need 3 weeks to file my affidavit.
be listed again on 26th of June 2023. The affidavit be filed by 23rd of June. The instructions so submitted is kept on record and marked with the letter X.
Value of light.
45,
Yes, what has happened out here? He has not received the salary for a particular 121 days. Yes, Mr. Gogoi.
Well, P9 is appearing. Well, can it be taken up after some time? Well, he might be having some instruction.
Okay, as you are here, we take up the other matter. What about the other matter?
timing item 36.
Now, on this point, of course, my lord, we have gone through the para 22. That part, the FRBM part is not there. Lordship will grant us some time, my lord, if I will convey to the authorities. If required, they may, my lord, modify this particular point.
I'll direct them to dispose it.
Otherwise, Lordship will direct it, my lord.
I dispose it of.
No,
Directing them.
Lordship has
giving-
pointed out, my lord. Let us, my lord, have a conversation with the authorities.
No, I have to put a specific question to you.
Yes,
as to
on
when there
10-4.
is a specific direction, we are not concerned. The direction was specific that any person who have been working in a casual capacity or so and so for 10 years should be given the benefit of this. You have given the benefit of everybody. They have put his name in the additional list at number 5. And why he shouldn't be getting the benefit? When the ARFBM Act was not within the fold of that, you could have very well pointed it out before the authority, before the division bench. You have not. So better off either you file an appeal against this order, otherwise, until help it.
No, well, that was not the point, my lord. That was not the issue raised before the division bench. There was no stand as such of the finance department. Now, if it has
Understood. But therefore, it is you are bound by the order of the division bench. So I'll dispose it of directing them to give
No,
the
Lord, she will
benefit.
grant me 1 week's time, my lord. Let me
Last
convey to
week
the
also
authorities.
1 week time I have been given to you. Last time I gave it on 15/5 and gave you 14 days.
Lordship.
So it has been just,
15/5.
let me see. On 1/2/2023, the same question was taken up when Mr. Arbo Pujari sought for some time. I gave him on 10 days.
10.
After 10 days, when the matter came up before this court, this time instruction was sought by Mr. M.K. Devnath. Then after that, when again the matter come, Mr. P. Nayak seeks for the same instruction and the same repetition of the orders passed by this court. Then comes you. You appeared on 15/5 and said that to give you 2 weeks. And accordingly, 2 weeks was duly given. Now you want 1 week.
Lordship, let it be last answer. Apparently, my lord, it's not there, my lord, in therapy.
But the problem, what happens out here is that he's lucky to get the matter listed today. That this court is taking it up. Sometimes it gets left over. No? You can't help it. Mr.
S.J. Sharma.
S.J. Sharma, the learned counsel, appearing on behalf of the petitioner. Ms. B. Devi N. Bora appears on behalf of the Panchayat and Rural Development Department. Mr. B. Gogoi appears on behalf of the Finance Department. This court on 15/5/2023 sought for a specific instruction from the Finance Department as to whether in pursuance to the directions passed by the division bench of this court in its judgment dated 8/6/2017 in the case of State of Assam versus Upenda. The respondent authorities can deny the benefit of the state judgment on the ground that the petitioner's appointment was made subsequent to the coming into effect of the AFRBM Act 2005, when the said issue was not raised before the division bench. The learned counsel appearing on behalf of the finance department further seeks accommodation of a week so that he can obtain the instructions in that regard. List the matter again on 2nd of June 2000. No, not 2nd of June. On
9th.
9th, I'm not there. On 12th of June 2023, on which date the learned counsel for the finance department shall obtain the instruction as sought for without fail.
Item 46.
Yes.
Here also I'm holding the old instruction. Because
old instruction.
As my old instruction, they have submitted the proposal for the arrears for in the financial year 22-23 on 17th of March, madam. So now we have to resubmit the proposal for the financial year.
You have not submitted till now.
That instruction I don't have, madam.
Yes, finance. Have you got any information on this?
No, my lord. Otherwise, my lord, area salary, there is already a office memorandum of the finance department that for area salary, my lord, it is not required that the finance department has to be moved. Concurrence can be given, my lord, by the administrative department concerned. Only in case of, my lord, scarcity of fund or if there is any break in service, in those kind of matters, my lord, finance concurrence is required. Here, my lord, it appears, my lord, we have not received any proposal. Otherwise, if proposal has been sent, at least I have the proposal number from my colleague.
Because madam, we have to submit the fresh proposal, madam.
To?
From the director to the government, madam.
That you have done it on 17/3.
That is, madam, for the year 22-23. That year has already been gone, madam. We have to resubmit it, madam.
When?
Well, why? They submitted or not, madam? That information I don't have, madam.
This was the instruction we have asked them. We'll take it up after some time.
Yes, madam.
47.
Regarding non-payment of arrears, kindly peruse last order dated 3rd of May 2023.
Yes, elementary.
(47) Yes, my lord. Here we have sent a proposal, my lord. In fact, I have. Here, my lord, on 2nd of May, my lord, we directed the director of district elementary education officer to submit the proposal.
Submit the what proposal?
For area salary, my lord, amounting to rupees 92,790 rupees.
That was done a long time back.
Yes, that is 16.
And as such, I fixed it on 3rd of May.
No, my lord, this instruction of 2nd of May, my lord.
Understood. That is why I have taken, this aspect was taken on 3rd of May. This instruction was produced by Mr. P.N. Sharma on the last occasion.
My lord, may I take it up after some time.
You are
Both the cases.
requested to furnish the correct salary statement along with non-royal certificate countersigned by the concerned imam for the financial year at an early date for taking further and necessary steps for sanctioning of the amount on or before 6/5/2023. That was the instruction.
Yes, ma'am.
And that is why I fixed it on 29.
My lord, may I take
This
it up
aspect was very much taken on 23rd of May.
after a few minutes, my lord. I will, for both the matter, I will open instruction, my lord, whether they have submitted the face proposal or not.
53,
Non-payment of arrears salary, last 3/4/2023. This could directed to respondent number 4 and 6 to apprise the court why the it has not been paid.
Yes, who is appearing for
BTC, my lord.
BTC? Fellow, none appears. We asked that BTC fellow, who is that person?
He should
BTC, we asked the Director of Education. Heard Ms. A. Buzabura, the learned counsel, appearing on behalf of the petitioner. Mr. N.J. Khatonia appears on behalf of the respondent number 1 and 2. Mr. Arba Pujari appears for respondent number 3. Mr. Nan appears on behalf of the respondent number 4 and 6. This court, by an order dated 3/4/2023, had directed the learned counsel appearing on behalf of the respondent number 4 and 6 to apprise this court as to why the petitioner has not been paid the arrears salary for the period from 16/10/2015 to 14/7/2022. However, none has appeared on behalf of the respondent number 4 to 6 when called. Accordingly, this court fixes the matter again on 16th of June 2023. On the said date, if the learned counsels on the said date, if the learned counsels appearing on behalf of the respondent number 4 and 6 is not present, the Director of Education, BTC Kopraja, shall be personally present at 10 p.m. 10 a.m.
Your Lordship, and
10:30,
similar case was
10:15 a.m. Oh, time is changed. Huh?
Lordship, similar nature of case was moved before this court on the same day, that is on 3/4/2023, WTC number 1904. That matter be along with this matter.
No. Let us go with this one. That matter is not there, no? So this matter at 10:15.
55,
Yes, madam. Why is not then entitled to the Upendra's judgment?
Lordship, instruction on this case.
Instruction doesn't come. Instruction come very difficult.
Quick time may be granted.
I gave you more than a month time. Who appears for finance? You. Yes, why is not entitled to the, as per the Upendra's judgment?
Yeah, my lord. Yeah, we have to file an affidavit because they have challenged that notification at page 37.
Page
37 of the writ petition.
Why they have challenged it?
Because, my lord, of that AFRBM. AFRBM, my lord, issue. Just some time ago, my lord was taking up a matter, my lord.
The benefits as entailed above shall be admissible on specific recommendation of the REA in compliance with formal approval. Where? Where does it say about the AFR?
The first paragraph, who were engaged prior to FRBM period, that is 1st of September 2005.
Where? Page 37.
Page 37.
First paragraph.
First paragraph
In supersession of the finance notification,
the following are hereby notified for compliance by all state government departments as applicable for masteral works as casual and similarly placed employees who were engaged prior to AFRBM by September so and so. There, my lord, the benefits are there. Number one, fixed wages remuneration 15,900. Then works as categories of workers. Number two, my lord, who are already drawing higher pay band will continue in the existing pay scale. These employees will draw their wages under the head of accounts. So number four, my lord, further eligible so and so will be covered under the Pradhan Mantri Suraksha Bima Yojana, Pradhan Mantri Jivan Bima Yojana, and Atal Amrit Abhiyan. And the premium for the same will be paid by the government because these, my lord, fringe benefits have been given in view of, my lord, paragraph 22. These, my lord, benefits are health insurance and other benefits has also to be given under the dictum of the division bench decision, my lord, in Upenda. Now they are challenging this.
You were appointed after the FRBM period.
Yes, some are prior and some are post, your lord.
Huh? Some are prior.
Prior and some are post, your lord.
So the prior ones, why they shouldn't get it? Who are prior?
Your lordship, those who are appointed working for 10 years, your lordship.
You know, my lord, here who were appointed prior to 19/2005, perhaps that instruction will have to come from them because they are the administrative department. I am only, my lord, to defend this notification, my lord, at page 37, which my lord has just now seen.
No, that particular notification has come when? AFRBM 19.
19. That is an act. That is an act, my lord, of the legislature.
But none of them are there who come within the AFRBM period. 19/2005.
Yes.
All these are 22/2005, 12/2005, 22/2005, 41/2005, 42/2005, 38/2005, 11/3/2005, 16/2005, 26/2005, 42/2003. How does they come within the ambit of the AFRBM? And why you are challenging unnecessary notification?
No, your lordship, if your lordship see the annexure number 1, your lordship, here the PNRD has recommended the your lordship both the prior and the post FRBM, your lordship.
We are not concerned. Are these petitioners have anything to do with that? You have joined prior to AFRBM period. AFRBM period starts from 19/2005.
Yes.
How are you relevant? Why you are unnecessarily fighting, drawing the wrath of the finance department?
Your lordship, give us one day, your lordship.
For what?
Give us some time, your lordship. Your lordship, give us some time, your lordship. On next day, I will argue, your lordship.
For what?
To defend this, your lordship. Your lordship.
Mr. Counsel, I hope you have understood what this
Yes,
court
yes,
is.
yes, lordship. Yes.
This court says that there is no necessity of challenging a notification when you come already within the ambit of that notification. Then
They are enjoying all these benefits. In 15,900, my lord, that was lesser amount. It has been increased to 15,900 with DNS allowance. And the pay revision will also be applicable to them. This is what exactly Jamjit Singh says, my lord.
Understood, but then they come not within the problem with the AFRBM thing.
Apparently they do not come, but since they are the employees of the PNRD department, perhaps my lord, PNRD department is required to traverse this paragraph 5, only paragraph 5, because in paragraph 5 of the writ petition, they have my lord given a list, date of joining, because the date of joining, my lord, date of engagement, my lord, assume significance here, in view of AFRBM.
Because all these appointment orders are there, which categorically show that they are there. And in that particular list, your name must be there. Your name was not there, recommended. You don't know that.
Some typing.
Hey, এখন ফাইল এটা আছিল ন এইমাত্ৰ যে ঠিক কৰিছো 12 জুনত এই একিতে এপিয়াৰ কৰি Madam, what was the item number you just appeared?
36, my lord, big over appeared, my lord. 36.
36 যোনটো আইটেম আছে নহয় তাতে এখন লিষ্ট এখন আছে Mr. Kaman,
Yes.
you do one thing, take that file.
Yes.
There's a list enclosed out there as annexure X or something, or letter X or Y. Have a look whether your name comes within it.
There may be, my lord, some typing mistakes also. I do not know. If lordship may be pleased to come to page 10 of the writ petition for a moment, my lord.
Yeah.
My lord, the petitioner serial number 8. Serial number 8, my lord, will find the third column. It is 1/9/2005. That is the date of engagement. And in the fourth column, it is seen, my lord, that it is 1/6/2005, date of joining.
That will be typographical error.
No,
Your
no,
lordship.
so therefore, I am making this submission. So let the PNRD department, my lord, traverse this paragraph 5. But they will be in a position, my lord.
No, in this page 40, annexure page 46 of your petition, your name is there. No. And why haven't you enclosed all the letters? Why you are craving leave, Mr.
Your
Counsel?
lordship, some documents are not with us, your lordship.
Then
That's why.
so you withdraw their cases. You have no business out there.
Your lordship can directly respond in your lordship.
Why? This court, you want this court to be make a fishing and roving inquiry for you, collect your evidence. Huh?
Let them scrutiny, your lordship.
Why they should scrutinize when you have not
We are
made out a
eligible,
case?
then your lordship.
Whether their names were recommended by the parent department, my lord, to that extent, my lord, the pleadings are silent.
Now that can be seen from these files. There are 5 annexures which were submitted.
My lord.
Where is that file? How can you?
In the if my lord comes to page 46 of the present matter, my lord, which my lord is taking, page 46. Page 46.
Yes, 46.
Yes, in pursuance of government order
That I've seen it.
Yeah. No, my lord, here Lordship will kindly mark the following casual employees under PNRD department who were engaged prior to AFR BM period 1st September 2005. So that list petitioners have enclosed, but they have not disclosed, my lord, whether their name figures here.
But why haven't you enclosed these documents, Mr. Counsel? Why haven't you not enclosed this counsel? Petition number 1, 2, 3, 4, 6, 7, and 10 hereby craves leave to refer and rely to. You are saying that you crave leave to refer and rely. You bring this on record.
Yes, sir.
Heard Mr. R. Kannan, the learned counsel, appearing on behalf of the petitioner. Ms. N. Bora appears on behalf of the respondent number 1 and 3, and Mr. R. Bopuzari appears for the respondent number 2. Upon perusal of the paragraph number 5 of the writ petition, it transpires that only the engagement letters of petition number 5, 7, and 8 have been brought on record but in the form of Annexure 1 series. However, the documents pertaining to the petitioner number 1, 2, 3, 4, 6, 7, 9, and 10 have not been brought on record, and the petitioners therein have sought to crave the leave of this court to refer and rely to such appointment letters. This court is of the opinion that the said documents has to be brought on record for the petitioner to make out a case for issuance of a writ. The learned counsel for the petitioner submits that he requires 4 weeks to do the same. In the meantime, accordingly, the matter stands adjourned till 24th of July 2023. In the meantime, the petitioner is given the liberty to file an additional affidavit bringing on records the said documents. The Panchayat and Rural Development Department is further directed to file their affidavit without fail on or before the next date.
58.
In this case, I have informed the parties, my lord.
Oh, that matter.
My lord.
Yes, yes.
My lord, I have taken few steps after the order of this court. I have communicated letter to registered post. The system showed that it has reached, but
he received, my lord. Call me, my lord.
Then what has happened?
No, thereafter, no information.
Okay.
so thereafter, my lord, I have requested this police headquarters, the agrarian office, to take steps. So what they have done is, my lord, they have written a letter to the district SP of Jharkhand, and they will meet the person. Somebody from the SP office will go there, meet the person. They will inform her about the case, and action taken report will be very soon be given to me. That is what they have communicated from the police headquarters.
Heard Mr. Ardhar, the learned counsel, appearing on behalf of the Rahul Dhar, appearing on behalf of the learned, heard Mr. Rahul Dhar, the learned Amicus, appointed by this court, who submits that in pursuance to the order dated 21/4/2023, he has taken steps and to inform the petitioner for filing a representation before the Treasury officer, no?
My lord.
For filing a representation before the Treasury officer so that the petitioner gets the benefits to which she is otherwise entitled to under law. Mr. P.J. Saikia, the learned counsel who was earlier engaged in the matter, was also present in the court, who further submitted that the petitioner have been apprised about the same, and then have been also apprised about the same. So, be that as it may, let this matter be listed after 2 months.
In the meantime, yeah.
2 months, that is on 26th of July 2023. In the meantime, the learned counsel Amicus, Mr. Ardhor, shall further pursue so that the petitioner gets the benefit of what she is otherwise entitled to under law. The registry shall show the name of Mr. Ardhor as have been in the cause list in respect to the instant matter as an amicus. The instruction so placed by Mr. Ardhor is kept on record and marked with the letter X.
Timing item 45. 45. I know 12.
This matter, madam, will I seek accommodation, madam.
Why?
Will like to file a reply, madam. They file an affidavit of opposition, and a certain other point has been raised by them. Now they are, my lord, disputing our promotion as a professor, my lord. We are readers, but that has been assailed, my lord. And if we don't reply to this, my lord, it will remain as an admitted fact, my lord. Very limited time, my lord.
They filed the affidavit on 4/5/2023.
Yes.
Huh?
Yes, madam. They file on.
You want to file a reply?
We'll file a reply within a very short time.
Mr. A.R. Tawildar, the learned counsel appearing on behalf of the Higher Education Department? No. Appearing on behalf of the Tejpur University.
Respondent number 4, your lordship.
You?
UGC, your lordship.
And appears on behalf of the Tejpur University, submit that the respondent number 5 have already. Respondent number 5 is?
Respondent number 4.
Which 5?
5 is.
Who has filed the affidavit?
It is filed by Registrar Tejpur University, madam. Respondent number 5, Registrar Tejpur University.
Submits that the said respondent, Mr. A.R. Tawildar, the learned counsel appearing on behalf of the Tejpur University, that is the respondent number 5, submitted that the said respondent have filed the affidavit on 4/5/2023. Mr. Your name?
SD.
So and so appears on behalf of the respondent number 4. Mr. D. Gogoi appearing on behalf of the petitioner submit that they would like to file a reply against the said counter affidavit filed by the respondent number 5 and 6 for an accommodation. Accordingly, list the matter again on 28th of June 2023. The petitioners shall file their reply by 26th of June 2023. Yes, what are you challenging here?
This is recovery of pay, madam. Recovery of pay. They say we have been bestowed an additional amount of beyond our what we're entitled to. And my lord, they have been giving promotions to us, which were not, we didn't ask for promotions. They gave us a promotion out of line, and now they are sought to recover after lapse of this benefit was extended to us in 2006, my lord, and demand was made in 2017.
So then your case is covered by Rafiq Masih.
And after that, my lord.
But you were put to notice.
And my lord, another issue has been also raised by them, my lord, that at para 5 of the affidavit, that our selection as a professors were not, my lord, we're out of rules, my lord. It was given to us, even though we didn't complete.
So then they can do it, whatever they want to do it, they will do
So
it.
this, if this is the stand, my lord, we have to reply. Otherwise, my lord, it will be.
No, you reply. There's no worry with that. But I'm not concerned with those aspects. I am only concerned with
para 5, page number 109, madam.
I'm concerned with another aspect. So everybody recovery is being sought.
Madam.
Everybody has a separate cause of action.
No, my lord, same. To find the same order, my lord.
So
we are given restored the.
okay, then we do one thing.
My lord.
We stay the order which was there only in respect to the petitioner number 1. Did it happen? You say it is same. So we stay the order only in respect to petitioner number 1.
My lord, we can wrap it up this matter in the next day fixed matter.
No.
Until
We only stay on that aspect. Everybody is a different man. How are you joining everybody together?
All the petitioners were readers, my lord. They were given. All the petitioners were readers in the post of readers, and by a.
So what? Readers, every reader has a different thing. How are you joining everybody together?
They are given redesignated as a 2006, my lord. Everybody was redesignated as a common order, my lord.
So
my lord.
You are entitled. Therefore, let me stay the order on the stay which is there. I'll modify only in respect to petitioner number 1. Would it suffice? Others?
As regards that, my lord, I have.
It further appears on record that there are 8 petitioners. However, the court fee of only 1 petitioner has been paid. Because the cause of action in respect to the instant writ petition is as regards the individual action, is as regards the recovery sought from each of the petitioners. Because under such circumstances, each petitioner has to pay the court fee.
That we can pay.
The learning counsel for the petitioner submits that the deficit court fee shall be paid on or before the next date.
Deep level.
14.
May I please your lordship?
Yes, Mr.
My lord, the petitioner before your lordship is the assistant teacher lordship of Howda High School lordship. The school was taken up by the government on 1/1/2013, and services of the petitioner was also provincialized.
Pay the allowance in the areas of the petitioner as assistant teacher with effect from a month till date. With 10% per annum for her salary is illegally and will withheld. Yes, madam, why have you withheld that money?
Lordship, on the last occasion, your lordship had asked us to file an additional affidavit, your lordship.
You filed it?
Lordship.
Where is it? On 11/5 you have filed it. Yes. Tell me. Whereby the event of such a close by the year will before the education tribunal. Who is the petitioner? Mumtaz Ali?
No, Lordship. Bonchibala not your Lordship.
Then what happened? Why? What?
Lordship, Bonchibala was provincialized. Provincialization order is 17/8/2013, your Lordship. That provincialization order was challenged by Mumtaz Ali. He is respondent number 6 here, your Lordship. In the first round of litigation, your Lordship, that is WPC 955/2013.
955. Okay.
Lordship.
Then?
There, your Lordship, he had challenged the provincialization order in favor of petitioner. So that in that an interim was passed, your Lordship, an interim order. In compliance of that interim order, your Lordship, her provincialization order was stayed. Lordship, petitioner's provincialization order was stayed. Then it was disposed of, your Lordship. A direction was given to make an inquiry. District scrutiny committee will make an inquiry and thereby decide.
But it was set aside.
No, your Lordship.
Then what is
Direction
the
was given.
If it was disposed of, what remains then?
Lordship, it was stayed for the time being.
But there was a direction.
Yes, your Lordship.
So the petition was pending.
The petition was disposed of.
It means something has to happen to that order. Either there has to be set aside.
No,
or was it made subject to inquiry?
No, subject to inquiry.
Then what
subject
happened?
to inquiry. And in the inquiry, it was decided in favor of the petitioner. Then again, there was a second round of litigation. Again, respondent number 6 challenged her provincialization. There again, an interim was passed, your Lordship. That has been brought into record, your Lordship. The interim is at page 49, your Lordship, annexure A.
49.
49, your Lordship.
Yes. M.U. Mondal, the learned counsel appearing on behalf, appears on behalf
last
of
line.
Man. As for the respondents, when so even the benefit of even
Benefit of
the
provincialization.
petitioner takes step for women. The next return, the benefit of provincialization shall not be given effect to the respondent number 7.
Respondent number 7.
Then
again, the benefit that was given, your Lordship, that was again withdrawn.
Benefit to the respondent number 7, the petitioner.
To the petitioner.
Then
because of the interim, your Lordship.
Then
your Lordship, the matter was disposed of, your Lordship. It was disposed of, directing to file a petition before the education tribunal.
Okay, so this court, did the court stay the petitioner's the appointment?
Because here, your Lordship, there was an interim.
Understood, but
that was not vacated, your Lordship. Because this
no. How can they be in time? The matter has been disposed of.
Lordship.
How can you keep on the matters? Either the order has to be stayed, either set aside, of course.
Lordship.
And if the court has disposed it of, then I'll make it clear that there is nothing out there. You should be entitled to.
Lordship. Because of that interim, again,
I think this is the confusion and
Lordship,
arises because of the mistakes we have committed.
Lordship, this is the reason why the salary has been stopped.
Okay.
That I have stated in 7, your Lordship, paragraph 7.
Anything else, Mr. Sharma?
Lordship, this.
You are entitled to your salary.
Lordship.
Okay, I pass the order.
Lord.
Heard Mr. R. Sharma, the learned counsel, appearing on behalf of the petitioner. Ms. D. Musahari appears on behalf of the respondent, Education Department. What about the respondent number 6?
He has retired, your Lordship.
He's a retired.
Lordship, he has retired by now.
But he has not been provincialized ever.
I appear for respondent 4, Treasury Officer.
You are the person who is going to pay. Mr. R. Bopujari appears for the respondent number 4. The instant petition has been filed by the petitioner being aggrieved by the inaction on the part of the respondent authorities in not making payment of the salary to the petitioner with effect from 1/1/2023 till date.
1/1/2013.
For 1/1/2013 till date, for which the petitioner have sought for a direction that the respondent authorities should pay the said amount along with interest at the rate of 10% per annum. It appears on record that on 17/8/2013, the services of the petitioner was provincialized with effect from 1/1/2013. In the said order dated 17/8/2013, the petitioner's name appeared as serial number 4. It further appears that the respondent number 6 herein challenged the said order of provincialization of the petitioner in WPC number 955/2013. This court, by an order dated 28/10/2013, disposed of the said petition, directing the Director of Secondary Education to cause an inquiry through the District Scrutiny Committee represented by the Deputy Commissioner Dorong in respect of the grievance of the petitioner, that is the respondent number 6 herein, petitioner therein, that is the respondent number 6 herein. It was further made clear in the said order that depending upon the outcome of the said exercise, the future course of action in the matter would govern. It further appears that the Inspector of Schools, Dorong District Circle, submitted an inquiry report pursuant to the order dated 28/10/2013. In the said inquiry report, it was found that the petitioner, that the respondent number 6, Mumtaz Ali, was senior to the petitioner herein in the category of Assistant Teacher Arts of Halda High School. But the name of the petitioner was recommended by the District Scrutiny Committee as the 3rd assistant teacher to the DAC Assam on the basis of the staff pattern submitted by the headmaster through Sri B. Nath. Now, though Sri B. Nath was junior, though the petitioner was junior to the respondent number 6 herein in the same category. Subsequent thereto, thereafter what happened?
Lordship, this inquiry was submitted, Lordship, and Lordships, then this.
Subsequent thereto, on 26/2015, the Director of Secondary Education passed an order stating inter alia that the order number TC/SCC, SCEC is smaller, oblique 115/2013/19, dated 17/8/2013 shall hold the field, and the petitioner would be entitled to receive salary on the strength of provincialization order dated 17/8/2013 and the approval of the Finance Department accorded by letter dated 1/2/2014. it further appears on record that the respondent number 6 thereafter filed another writ petition being WPC number 4828/2015. It appears on record, as would be apparent from the additional affidavit filed by the respondent number 2, that in WPC number 4828/2015, this court had issued notice on 19/8/2015 making it returnable on 5/10/2015, and in the interim till the next returnable date the benefit of provincialization shall not be given to the, well, and in the meantime till the next returnable date it was directed that the benefit of provincialization shall not be given to the petitioner who was the respondent number 7 in the said proceedings. Thereupon, the Director of Secondary Education passed an order on 5th of November 2011.
15, Your Lord.
5th of November.
2015.
15. Whereby, although the order dated 19/8/2015 state the order of provincialization of the petitioner till the returnable date, but the Director of Secondary Education, in view of the order dated 19/8/2015, withdrew the order dated 7/7/2015 until further orders. It may be reiterated herein that the 7/7/2015 order was passed by the Director of Secondary Education by taking into account the enquiry reports so submitted by the Inspector of Schools pursuant to the directions passed by this court dated 28/10/2013 in WPC number 2955/2013. It further appears from the records that this court, by an order dated 24/5/2019, disposed of the writ petition, that is WPC number 4828/2015. perusal of the said order dated 24/5/2019 shows that this court did not interfere with the order of provincialization dated 17/8/2013 or the order dated 7/7/2015. And directed the respondent number 6, who was the petitioner, directing the petitioner in the said proceeding to approach the educational tribunal in the district of Darang including filing an application for stay, if any. Therefore, with the disposal of the said petition without interfering with the orders dated 17/8/2013 as well as the order dated 7/7/2015, the entitlement of the petitioner therefore had the entitlement to receive the salary on the basis of this order dated 17/8/2013, which was made with effect from 1/8/2013. 1/1/2013. It further appears from the affidavit filed by the respondent number 2 that it is on the opinion that there was no clear and categorical observation by this court in the order dated 24/9/2015. 20, the date. In the order dated 24/5/2019, that the interim order dated 19/8/2015 have been vacated. The petitioner have not been paid her salary. It further appears from that additional affidavit filed by the, where is that affidavit that he has not filed any case? Who has filed that?
Lordship,
You have filed that, no?
I have filed, Lordship. I have filed on 8/5.
It further appears from the additional affidavit filed by the petitioner that the respondent number 6 thereupon herein did not approach the educational tribunal. Next. In the backdrop of the above facts, this court have heard the learned counsels for the petitioners as well as the secondary education department. It is relevant to take note of that in the meantime, the respondent number 6 had crossed the age of superannuation. It is further apparent from the order dated 28/10/2013, passed in WPC number 955/2013, as well as the order dated 24/5/2019, passed in WPC number 4828/2015, that there was not, that the orders dated 17/8/2013 as well as the order dated 7/7/2015 have not been set aside and quashed. The disposal of the writ petition that by the order dated 24/5/2019 further shows that the respondent number 6 herein was given the liberty to file an application, file proceedings before the educational tribunal at Darong, in the district of Darong, along with the stay application, meaning thereby the stay order stood vacated. It is otherwise also not res intriga that once the writ petition, once the proceedings have been finally disposed of, the order which is the subject matter before the court has to be either set aside and no stay and the interim orders so passed culminates with the final order. Under such circumstances, as the order dated 17/8/2013 as well as the order dated 7/7/2013 was not set aside, and there was no proceedings initiated before the educational tribunal, this court is therefore of the opinion that the petitioner would be entitled to her salary from 1/1/2013 in terms with the order dated 17/8/2013 as well as the order dated 7/7/2015 passed by the Director of Secondary Education. Accordingly, this court therefore disposes of the instant writ petition with the direction to the Director of Secondary Education, that is respond number
2, Lord.
for whom are you appearing?
Lordship, second director, your lordship.
Directing the respondents, the official respondents, to take appropriate steps so that the petitioner receives her area salary and continues to receive her salary in terms with the order of provincialization dated 17/8/2013 and the order dated 7/7/2015. The said exercise be completed within a period of 4 months from the date a certified copy of the instant order is served upon the respondent number, Director of Secondary Education.
Lord.
Who? Number?
Now, number 2.
Number 2.
What's this interest?
What interest? Interest will consider later on. Not now. First you you get your, then we'll.
Timing at 45.
It is further observed that if the said amount, so that if the petitioner is not paid the area salary as well as his area salary within the period as stated herein above, the respondent shall be liable to pay interest from such date, from the date of their default in terms with the directions passed herein at the rate of 10%. 10%.
45.
More. I am paying for 2 weeks time to submit a fresh proposal, both 45 and 46.
Fresh proposal?
Yes, my lord. Hold on, not 40, 46. Sorry, my lord. Not in 45, my lord.
What is this? 45. Who is appearing in 45? Mr. Nayak, where is he? 46 video. Yes.
Here 46 and 47. Both the item, my lord, I am paying for 2 weeks to submit fresh proposal for the year 23-24, my lord.
At the request of Mr. N.J. Khatonia, the learned counsel appearing on behalf of the
Elementary education.
one is secondary. Both are elementary.
Both are elementary, my lord.
On appearing on behalf of the on behalf of the elementary education department. The matter stands adjourned to 19th of June 2023. It is made clear if the instructions sought for by this court item 46 by the order dated 24/3/2023 are equal to 47 not by the order dated 2/3/2023 and 3/5/2023 are not obtained. This court shall have no other option but to seek the personal appearance, pass appropriate direction for personal appearance of the Director of Elementary Education on such date as may be fixed by this.
Oblige.
Yes, Mr. Nayak.
Lordship, in this case, we have already received instruction, Lord. It has been sent for signing, Lord.
What is that instruction?
If Lordship. Lordship, it was, they have furnished me the copies of the attendance sheet, Lordship. And on the basis of that, the reporting officers report, Lordship.
Now, this is regarding 121 days.
Yes, Lordship.
Yes, what is the problem?
The problem is he has been found absent, Lordship, in those days, Lordship.
So you have to file your affidavit.
Lord.
So you go on the principle of no pay, no work. No work, no pay.
No work, no pay.
Did the counsel for the petitioner appear at that point of time earlier? Huh? No? Okay, anyways. Mr. P. Naik, the learned counsel appearing on behalf of the respondent number 2, 3, 4, and 6 submits that he has already received the instructions in the matter which whereby he submits that the petitioner would not be entitled to the amount of to the area salary for the 121 days as he was found absent, taking into account the specific stand which have been taken by the respondent number 2, 3, 4, and 6, this court finds it relevant that the said aspect of the matter be brought on record by way of an affidavit so that the petitioner is in a position to rebut to such allegations. The learned counsel for the respondent number 2, 3, 4, and 6 submits that he would require how much?
2 weeks, Lord.
Submits that he requires 2 weeks' time to file the affidavit. Taking into account the same, let this matter be listed on 28th of June 2023. The affidavit be filed by 21st of June 2023. Mr. Naik, you are also for BTC, na?
All the cases are not allotted to me, Lordship.
One matter,
Lordship,
Mr. B.
yes,
Chaudhary was there, he did not. So I've asked the director of there to be present.
Subsequently, somebody informed me, Lordship. In fact, it was allotted to B. Chaudhary, Lordship. Today he is absent.
So I've asked the director to be there. Education, either the council should appear on with instruction or the director to be present.
Lordship, I'll take care of that.
16,
Or should I put the thing you have appeared
Lordship may record my name also.
and obtain the instruction?
Lordship, I think.
এইটো কিমান নম্বৰ? What is that?
53 law.
Item 53.
53. Hey, that 53 জনে লৈছে. So and so appears for here. 6 for an instruction in terms with the order dated so and so. এইখিনি লেখা আছে. দেখলে shall obtain the instruction without fail.
Lordship. Obliged.
16,
Yes.
My lord, today itself I have received a copy of the affidavit filed by the respondent number 3, my lord. Perhaps they have filed today. My lord, I have to go through it.
Yes, madam, what is your affidavit?
Lordship.
Oh, that, yeah. I heard Miss, who has filed?
Respondent
Lordship,
number 3.
Director, Secretary, Education. Respondent number 3.
The Ms. D. Musari, appearing on behalf of the Director of Secondary Education, submits an affidavit has been filed by the said director, said respondent. However, it is apparent, however, the same does not appear on records. Accordingly, lists the matter again on 19th of July.
seventeen,
Yes.
Pursuant to the court's direction, we have already filed a affidavit stating that forthwith the Business Municipal Board will release.
That matter?
Lordship.
KP Pathak?
Lordship.
Regarding that,
Lordship.
then what else you have a problem? That was the heard. They have filed the affidavit.
Lordship. 11-4.
That's when the respondent has filed a matter on. So then, only thing was that they were entitled to that if you, this was the affidavit, na? That in terms of the directions of this court, the deponent on specific instruction received from the newly man is that henceforth the BCM will be paying the regular salary of pay to each of the petitioners in terms with the office order dated so and so. As regards the area salary of the month, the petitioner may be given the liberty by this court to submit the individual representation here. Then you do it. Heard, Mr. P. Kakoti, the learned counsel appearing on behalf of the petitioner, Mr. D. Das. D. Das appears on behalf of the respondent number 1, 3, and 4. And Ms. Etalugda appears on behalf of the respondent number 2, that is the Director of Municipal Administration. This court, by an order dated 23/3/2023, after hearing the matter and taking into after hearing the matter at length, passed the following order, which is reproduced herein under. The 23 deed. In pursuance to the order passed on 23/3/2023, the executive officer of the Biswanath Chariali Municipal Board had filed an affidavit in terms with the order dated 23/3/2023. Paragraph number 2 of the said affidavit being relevant is reproduced herein under. Page 228 of. Taking into account that the Biswanath Chariali Municipal Board had given an undertaking before this court on affidavit that henceforth the petitioner, the municipal board shall give the regular scale of pay to each of the petitioner in terms with the office order dated 8/9/2014 and would consider the representation of the petitioners for area salary. This court therefore on the basis of the said undertaking, as quoted herein above, disposes of the instant petition. The undertaking so quoted herein above shall form a part of the instant order, and the respondents in the municipal board shall be bound to comply with the same. So the above the petition stands disposed.
That's okay.
You are seeking adjournment in the morning for this?
The long pending litigation comes to an end. Lordship.
18 to 30.
Key method. 18? 30.
My lord, that Plains Track Corporation, that matter.
Oh, yes, yes.
So, my lord, I'm placing this one instructions, my lord, if your lordship. Lordship, that 17 crore that
Advance
recently.
contingency proposal to the finance department amounting to demand by the demand is the amount required for payment of a year salary. Mention the sum of the retire have not moved the court for period. The total amount required for payment, including the first so you have moved now for 826.
826. My lord, the thing is that these are long pending issues of Plains Track Corporation. Recently, they have come up with this to us.
Where is the plain tribunal? Yes, you are there.
So, my lord, we are trying to help them, but at a time, if you go for 17 crore, my lord.
No, I understand.
So, my lord, now what we did is, my lord, in last.
We'll have it after 3 months.
After, yes, my lord.
In the meantime, you let us apprise this court what is the present situation. I think that is the way out how you get the money. If I dispose it of, nothing is going to happen. So here is the case. I have to keep on a continuing mandamus.
I am sharing this.
That is the only way how it is.
My lord, I am sharing this instruction with my friend, with finance. So we have moved to finance. Let's see now. Of course, we don't have even money, my lord. The department also doesn't have money.
No, the finance have the money. But as in the words of Mr. Borpuzari, if the department does not have the money, they have to move the matter to the finance. And the finance is very considerate in such aspects.
We are just trying to, my lord, bail out this Plains Track Corporation, my lord. That's it. They have been keeping, my lord, they should have paid this from their own.
They don't have the money.
My lord.
When you were appearing also, you also said we didn't have money. Now you are appearing for the department. Now you are putting the blame on that corporation.
No, my lord. I played very balanced, my lord, during that time. I said no money, but we are trying to garner money, my lord.
Okay. The learned counsels appearing on behalf of the petitioners, and Mr. Ardhar appears on behalf of the Department of Tribal Affairs, Plain, Government of Assam, and Mr. R. Borpuzari appears on behalf of the Finance Department. Mr.
Appearing on behalf.
Appearing on behalf of the corporation. So and so appears on behalf of the
corporation.
What corporation?
Plains Track Corporation.
Plains Tribes Corporation. Assam Plains Tribal Respondent. Assam Plains Tribes Development Corporation Limited. Pursuant to the orders passed by this court, main requisition kon diyo. 16 or kon diyo. Ebu kusura. That order to diyo. Di, baki buno. Economy mainly. Pursuant to the orders passed by this court on 27/4/2023 and 10/5/2023, the Department of Tribal Affairs had, pursuant to the proposal submitted by the Managing Director of the Assam Plain Tribes Development Corporation, have taken steps by submitting a proposal before the Finance Department of Government of Assam, being proposal number CF-WPT-0004 on 26/5/2023 of an amount of rupees 826.02 lakhs. Full stop. It has also been stated that after that the total amount to clear the liabilities as regards the pensioners, as regards the employee, as regards the retired employees and also the present employees would be rupees 17.19 crores. And as such, the remaining amount of rupees 893.48 lakhs would be placed, included in the supplementary budget proposal later on. The said instructions so placed on record is kept on record and marked with the letter. Why? Taking into account that there is some positive move on the part of the Department of Tribal Affairs, plain Government of Assam, to redress the grievances of the petitioners herein, this court fixes this matter again on 7th of August 2023. In the meantime, this court hopes and expects that the Finance Department of the Government of Assam shall do the needful so that the grievances of the petitioner, the long-standing dues of the petitioner, can be cleared at the earliest. Main part.
Item number 66.
Which one?
Exactly 66 item.
66. 66 bhara dibe yat.
Sixty and 66.
60 and 66.
Yes, ma'am.
Bhara dibe.
31 and 32.
Why so big files? Oh, that one. Karbi Anglong. Oh, this was the matter that day I was talking about. Karbi Anglong. In fact, that day, 2 days back, I have stayed this. There's a recovery being sought to be made. Yours is a...
Not, we had also, it has been stayed, recovery has been stayed.
Ah. So that matter, it was there 2 days back on Mr. A.K. Dutta was appearing. So that I remember this matter. So I said that he said that I have disposed of. I'm not disposed of.
No, Lordship. Lordship asked me to receive instruction, Lordship.
For appearing on behalf of the respondent that he would require some time to apprise this court as regards the development insofar as the consideration which is pending before the respondent authority for including the Karbi Anglong within the ambit of the notification. Yes, what happened?
Lordship, this matter has been referred to the subcommittee, Lordship. It is pending before them, Lordship.
Heard Mr. M. Kolita, the learned counsel appearing on behalf of the petitioner. Mr. B. Chakraborty appears on behalf of the respondent.
In item number 31, I am appearing like item number 32, SK Methi, Lordship.
Where is he? You are appears on behalf of the respondent. Mr. Pursuant to the directions passed by this court on 26/4/2023, Mr. B. Chakraborty, the learned counsel for the respondent, submits that the matter pertaining to pertaining as to whether the district of Karbi Anglong should be brought within the ambit of the notification dated 22/2/2019 is presently pending before the,
Has been referred to the subcommittee.
have been referred to the
Subcommittee, Lordship. SUV.
what subcommittee?
This is what the instruction says, Lordship.
The subcommittee for what? There is some subcommittee has something. Huh? Give it.
It's referred by the Ministry of Home Affairs, Lordship. The paragraph number 2, Lordship. First page. With regard to point number 1.
Is presently under consideration with the subcommittee, and a decision as deemed fit would be taken. It further appears from the said instructions so sent to Mr. B. Chakraborty and Mr. S.K. Mehdi, the learned counsels appearing on behalf of the respondents, that unless the subcommittee decides the RH factor matrix of deployment place of 20 battalion, it would not be possible to calculate the exact detail of the difference amount. Taking into account the same, this court fixes this matter. Now, the said instruction, which have been placed by Mr. B. Chakraborty during the course of the hearing, is kept on record and marked with a letter, with the letter X. This court again fixes this matter on 26th of July 2023, on which date the learned counsel appearing on behalf of the respondent shall apprise as to whether the subcommittee in question have taken any decision in the matter. Interim order is until further orders, na?
Yes, but interim order can be matter, not further order.
Huh?
Not further order matter.
Okay, interim order such so passed earlier shall continue till the next date.
34.
Yes.
That is pilot matter pertaining to area salary of the petitioner.
Why you are laughing? Huh? Area salary.
Yes, my lord. Issue was earlier decided by the honorable court, my lord.
Then
Your lordship will find, my lord.
setting aside an order dated demand wherein it has been held that the petitioner is not entitled to the back wages. Why?
Yes, my lord. Issue, my lord. Kindly.
Why you are not entitled to back wages?
My lord.
Where is that order?
My lord. Impugned order page
2021.
Page 45, my lord. 5 copy, my lord.
Page
45, my lord.
what is there? Finding the petitioner's mentor was in judicial custody. However, the honorable acquitted him that order and he was released from jail. The petitioner was released with conviction. What is this order? You have
Yes,
typed
my lord.
out.
Order of this honorable court, my lord. Start from page 41, my lord.
I don't understand. Kindly come to page 51, Mr. Katunia.
Yes, my lord.
Come to Roman 4.
After he joined in his school on 7/11/2017, so the petitioner was absent in his duties for 23/11/2007 to 7/3/2017.
So he is not, he was absent.
Yes, my lord.
From where?
It's seen that the petitioner did not perform his duties during the period which the salary is claimed. That is from 6/4/2012 to 29/2/2016. He was in judicial custody from 23/11/2007 till 5/4/2012.
What happened to the order? As regards your suspension, what happened? There was a departmental proceedings.
No, my lord.
What happened to the criminal proceeding?
My lord, he was acquitted. Initially, he was convicted, my lord, by the session court. But then he preferred appeal before the court, my lord. In this appeal, he was acquitted.
This court acquitted him.
Acquitted.
Then what happened?
After his acquittal, my lord, he filed a representation before the authority to allow him to join service. But his representation was not considered. Then he filed a writ petition, my lord.
He filed a writ petition.
Yes, yes, my lord.
When?
In the year
In 2019, 18, 5006.
no. This is the second writ petition, my lord.
Okay. First writ petition was for what?
Page 22, my lord.
What was that?
For allow him to join his service, my lord. Page 22.
The decision taken by director shall be communicated to the no. Where it was given in the above I am of the consider when the writ of mandamus be issued to the year to consider the prayer made by the petitioner addressed positively within 1 month. So there is no direction for reinstatement.
Yes, my lord. But then he filed a contempt petition. No action was taken.
Okay, then
After contempt petition, my lord, director passed the order, my lord. Your lordship will find page 20.
on 23/6, 23/9/11, I was acquitted by the Honorable High Court and this was taken against the accused person. He is allowed to join his service. However, he is not entitled to back wages from the date of his first arrest up to the date of his acquittal by the Honorable High Court by the order dated so and so. If any excess amount of salary was already paid to the so and so is to be recovered. Then
my lord,
he challenged this order.
no, my lord, he has not challenged this order. My lord, he joined his service, my lord.
Huh?
He joined his service, my lord.
You did not challenge this order of 23/11/2016?
Subsequently, he challenged, my lord.
When?
My lord, page 40, my lord.
This one. Then what happened?
My lord, your lordship offered
Considering the above disposition is disposed of directing the move particularly to look into the proposals forwarded by the district demand towards release of the salary of the petitioner for the period from so and so to February 16, which is also mentioned in the order annexed to the writ petition. Upon certain years shall pass necessary order for release of the entire exercise which is directed. Then,
my lord, he filed contempt petition, my lord. During contempt petition, proposal was sent to the government, my lord. But because of before releasing the same, my proposal left, my lord. Then your lordship.
so the director of elementary education has written to the state government to accord sanction
Yes, my lord.
of an amount of rupees 12 lakhs for the period from 6/4/2012 to 29/2/2016.
Yes, my
But the coordinate bench out here has only directed for this period only,
Yes, my lord.
not for any other period.
Not for any other period.
So then the director of elementary education directed for the purpose of area payment.
Yes.
Then
yes.
what happened?
Then, my lord, proposal was sent to the government for approval, my lord. In the meantime, a proposal left because of financial year, my lord. Then again, my lord, 2020 again sent, my lord. But because of Corona, my lord, salary could not be released, my lord. Now,
This
my lord,
order is in compliance to the order. Oh, there is another order, second order passed.
Yes, my lord. By the same authority, my lord.
Yes, Mr. Katunya, what is this?
Yes, my lord. In the first order, page 42, my lord.
Page 44.
First order, my lord.
No,
Page
but
42.
that, no, that I've seen it. I'm not on that. Kindly see page 44.
This is the proposal.
Understood. But here it is said, with regard, I have the honor to submit herewith an area proposal for an amount of remand only for the period from so and so in respect to the petitioner so and so. So when that authority
Yes.
has submitted the proposal, how can he then pass an order against it?
And subsequently, my lord.
How can he do that? I would have understood that the secretary passing an order to that effect.
Yes, my lord. The same authority reviewed the order, my lord.
How is it possible? Tell me. And when that too, this court had categorically observed,
The observation was to look into the proposal forwarded by the District Elementary Education Officer Hailakandi
towards release of the area
area
salary of the petitioner for the period from so and so to so and so.
Upon such examination, the Director of Elementary Education shall pass necessary orders for release of the salary.
Absolutely. So now, in pursuance to that, he has passed that order. And if you see, this is in reference to 5006 of 2018, and here submission of area proposal in connection with so and so and so and so. Then why again a change of heart of the authority? And how does he explain in his affidavit?
My lord, the explanation was given in the paragraph page 61.
Accordingly, the so and so order holding that the senior finance order found after going through the proposal and on relevant records of the petitioner is that the period during which the petitioner was not performing his duties. After release from judicial custody on 5/4, the petitioner was rejoined in his service on 7/11. Therefore, the writ petitioner was absent from so and so, so and so.
This is the reason, my lord.
But why that was not considered?
On earlier occasion. That has not been mentioned in the affidavit, my lord. That observation was made by the senior finance and accounts officer.
Understood. The senior, who is the senior finance accounts officer?
He is the officer from the directorate office only, my lord.
No, why this is the change in heart? Tell me. Huh? Oh, you see, one thing, if you're not wrong, page 44, you see. This is an order being done by whom?
Is 44 ordered by the
Is it for?
director, my lord.
Why is something mentioned on the side of it? Is it for? Okay, heard, Mr.
AHMR2.
AHMR Chaudhary, the learned counsel for the petitioner. Mr. NJ Khatonia appears on behalf of the Elementary Education Department. Upon hearing the learned counsel appearing on behalf of the petitioner, hearing the learned counsel for the parties, it appears that on January 4th, 2020, The Director of Elementary Education had written to the Secretary to the Government of Assam, sending a proposal as regards the entitlement of the petitioner for an amount of rupees 12,02,666, being the area salary for the period from 6/4/2012 to 29/2/2016. However, on 30/7/2021, the Director of Elementary Education held that as the petitioner was not in service, did not join the service till 7/3/2017, the petitioner was not entitled to. It therefore appears that there is a contradictory stand by the same authority. This aspect of the matter is, however, not highlighted in the affidavit so filed by the Director of Secondary Education,
Elementary.
the Director of Elementary Education. Under such circumstances, the learned counsel appearing on behalf of the Elementary Education Department is given 3 weeks' time for the purpose of putting on affidavit the reason why the same authority had passed 2 orders on 4/1/2020 and 30/7/2021. List the matter again on 26th of June.
Obliged.
35.
I have been newly engaged in this matter. I have been newly engaged.
May I please, Your Lordship? Your Lordship, I am for the respondent on behalf of Mr. G. Jalan. Your Lordship, we had already filed the affidavit in opposition, so this matter may be fixed for hearing.
Hearing?
Yes.
Look, what has happened in this case, the earlier engaged counsel, under some misconception, has filed this writ petition. This is for non-payment of pensionary benefit to the petitioner. Now, petitioner served in SBI. He was serving as guard as well as messenger. So he opted, after completion of 11 years and 8 months service, he opted for exit scheme for voluntary retirement. What has happened? The rule says SBI employees pension fund rules. It says, my lord, for become eligible to get the pension, one has to complete 20 years of service. And another option is there. If a person completes 10 years of service and he attains 60 years of age, then he can be eligible for pension. Now, in this case, he neither comes within that first 20 years nor within this 10 years, as he did not attain age of 60 and got the opted for voluntary retirement at the age of 56. Now, if I take your lordship to
No, Mr. Counsel, what do you propose to do with it?
Well,
if you don't come within the ambit of either of it, then
only thing remains in this case, my lord. He contributed certain amount towards employees' pension fund. So whether that amount can be refunded to him.
Refund his deposited amount under the pension fund. What
Under
do
the
they say?
employee's pension-
What do they say in the affidavit?
My lord, there stand in the affidavit, is only regarding the 20-year and 10-year.
Not about this, but you have made a specific prayer, refund him the deposit.
Yes.
Okay, we'll have it on. When did he retire?
In the year 2007.
7. Well, we'll have it on 16th of June. Or Mr. M. Chaudhary, the Learned Counsel, appearing on behalf of the petitioner. Madam, your name?
C. Subba, Your Lordship.
So and so, appearing on behalf of the State Bank of India. Taking into account that the petitioner had retired from service in the year 2007, this court fixes this matter on 16th of June 2023. Liberty is given to the petitioner to upgrade the matter.
Obliged.
Yes, any urgency?
I think 48.
Yes, what is that?
I think so widow, the husband has died and no pension is paid to her till today, and there is an order of the government that it should be given. Yes, 40.
40 or 48?
40. Kindly see 20, page 20. This will do everything clear.
Yes, sir. This has come last after 2022.
22 is the proposal, government's clearance everything, page 22. Islamuddin Borhuia, date of engagement, so and so. Conditions, Lordship kindly see, it is certified that the aforementioned one number of worker, one number is Islamuddin Borhuia, have fulfilled the following 4 conditions. He had been working continuously for 10 years or more as on 10/4/2006. That is the date of passing of the judgment in Umadevi's case, without a benefit of protection of interim order of any court or tribunal. Secondly, he had been engaged against sanction post. No record is available in their office, but it is admitted that I have been appointed in sanction post. Then he has been requisite qualification to hold the post. Then no more employees fulfilling the above 3 conditions are left to be considered after this time exercise. The above certificate has been furnished after considering the relevant certificates. Only in that office I was the only eligible person.
Then you have been regularized.
That was not.
I am directed to return you the proposal of service to union in regularization of service in and request you to resubmit the proposal after due examination. Then you have not been regularized.
Not regularized.
And how many years of service you had?
27 years I have served.
As a casual worker?
First time it was casual.
As a MR?
MR worker. First time I was.
Are you an MR or WC?
MR labor first. Then I was promoted to work just section assistant.
Work shut. Yes, Mr. Dhar.
Everything. Okay,
it all falls within your ambit. You are entitled to pension.
Yes, I am entitled to pension. Other gratuity, I will also get gratuity. Nothing is given.
No. Why he won't be entitled to as per that particular office memorandum of 2015?
Yes, office memorandum I have annexed.
Which one?
That is
not this 13, the other one. This is for regularization. We are concerned with pension. Where is that office memorandum?
S17.
Page?
717.
No. This is regularization. I'm not concerned with regularization. You are concerned with pension.
Yes.
Let us stick to pension. And you have not been regularized, no?
No, he has not been regularized.
Okay. So if he is not regularized, then why he should not get the benefit in terms of this particular office memorandum dated 6th of September 2003? In continuation of the department's so and so, it is reiterated that the State OM clearly lays down that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits. The focus is on 20 years of continuous service. After rendering 20 years of service, if the government servant is superannuated or incapacitated or dead, is not the moot point. Any confusion in that regard is against the spirit of the OM. Yes, if he has worked for 27 years.
My lord, this matter has come after a long time, my lord. We haven't filed the affidavit even, my lord. No instructions.
You don't file affidavit, not necessary. You just get your instructions. Huh?
I have also got some citations in this regard.
What citations? Heard Mr. M.U. Mahmood, the learned counsel, appearing on behalf of the petitioner. Mr. Ardhar appears on behalf of the respondent PWD department.
So regarding delay and providing sanction, those are regular. Those things are there.
The learned counsel, appearing on behalf of the PWD department, shall apprise this court on the next occasion as to why the office memorandum bearing number PPGP bracket P 196/92/61 dated 6th of September 2003 shall not be applicable insofar as the petitioner is concerned, taking into account that the petitioner had rendered 27 years of service and while continuing in service died in harness. The husband of the petitioner, huh?
And those are the citations I have given. Proofs I have given.
But you may be entitled to pension, but problem will be family pension.
Family, that is what, man.
Perhaps I will also get gratuity.
Gratuity you get, but not the family pension. Family pension, you have a problem.
I will kindly go through this.
No, whatever may be the rules is rules. Family pension, you have to be confirmed for 1 year.
1 year.
This notification allows you to get the pension, which obviously your husband will get.
So long he was alive.
No, but he died in harness. How can he get pension?
Exactly, that is what, my lord.
But gratuity he will get.
Gratuity he will get.
Family pension not possible.
Family pension not possible, man.
Illegally too. Shall not be applicable insofar as the entitlement of the petitioner to the death cum retirement gratuity
And other things like
as well as family pension. List the matter again on 21st of June 2023.
I don't know, maybe help with Parhat, right?
What?
Parhat.
I am here sitting these matters only. Everybody knows where. We go to a pension judge, they will say about me only. Don't worry.